Good morning, and I'd like to call this hearing to order. And don't put my time on yet. This morning's hearing is going to begin with a discussion of the Ratepayer Protection Act, a draft bill that would add several common sense safeguards in the EPA's proposed 111D rule for existing power plants, which is referred to by the agency as the Clean Power Plan. I want to welcome Acting Assistant Administrator McCabe, as well as a diverse group on the second panel representing those impacted by the proposed rule. And I just want to make a comment that we appreciate your being here, Ms. McCabe, very much. As you know, we have fundamental, divisive, really different views on this particular rule, but we do look forward to your testimony. We'll have a lot of questions, and appreciate your being here with us. And now I'd like to recognize myself for a 5-minute opening statement. I might say that in reading Ms. McCabe's testimony, I was struck by the comment that she was not aware of any instance in the last 25 years when Congress has enacted legislation to stop implementation or stay implementation of an air rule during a judicial review. To do so here, she said, would be an unprecedented interference with EPA's effort to fulfill its duties under the Clean Air Act. Now, I believe the key word in her statement is unprecedented. Anyone familiar with the Clean Air Act should not in any way be surprised that Congress would try to stop, slow down, or, as Ms. McCabe said, interfere with efforts to rush implementation of the rule for existing source performance for electric generating units. Why? We think you're overstepping your authority. We think you're now legislating. Experts in the Clean Air Act have described this proposed rule as extreme, radical, a power grab. One of the best characterizations of the rule was stated by Professor Lawrence Tribe, the highly regarded liberal scholar of constitutional law at Harvard University. Since this rule is more about changing energy policy than anything else, he said burning the Constitution should not be a part of our national energy policy. Whoever thought EPA would be attempting to become the energy czar for America? Professor Tribe said, at bottom, the proposed rule hides political choice and frustrates accountability. It forces states to adopt policies that will raise energy costs and prove deeply unpopular once the people realize what is happening, while cloaking these policies in the garb of state choice, even though in fact the policies are set and compelled by EPA. The EPA thumbs its nose at democratic principles by confusing the chain of decision making between federal and state regulators to avoid transparency and accountability. Now, when EPA Administrator Gina McCarthy testified before the Senate Environment and Public Works Committee on July 23, 2014, she said, "The great thing about the power plan is that it is an investment opportunity. This is not about pollution control." And the regulatory impact analysis of the proposed rule states that the impact of reduced climate effects has not been quantified. In other words, EPA does not claim that the proposed rule would affect the climate in a significant way. However, Ms. McCabe in her testimony today says we must address climate change. It is common mantra in the administration from the president through every political appointee. And yet this unprecedented rule, which will increase electricity rates, affect reliability, cost billions of dollars, make EPA the energy czar for America, will not have a significant impact on climate change. Everyone acknowledges that fact. So that raises a question. Why is EPA, at the direction of the President, rushing it through? EPA obviously wants this completed before the 2016 elections. Is it being done to create a legacy in the international arena for President Obama? Perhaps someone has decided it is urgent that the electricity business in America be radically changed. Experts familiar with this process have been taken aback by the convoluted arguments that have been developed to legitimize this proposed rule. As far as we know, it is the first time in the history of EPA where the agency lawyers felt compelled to include a separate legal justification for the rule, 104 pages to be exact. So we find ourselves in a situation where EPA, not Congress, is writing a new law. State attorney generals are filing suit to stop EPA. State regulators are pleading for help. Electric generating companies are facing uncertainty. Consumers are finding electricity rates going up, and no one knows for sure what the impact will be on reliability, or for that matter, the real reason this regulation is being rushed to market. In the history of the Clean Air Act, EPA has never been this bold. So if actions are not delayed by Congress or if they are affirmed by the courts, EPA will fundamentally redefine and reshape its regulatory reach for the next generation of rule makers in a way typically reserved for legislative bodies. So with the very utmost respect, people are asking Congress for help in reining in this agency. And that is why we've introduced this legislation, and we look forward to comments about it. At this time, I'd like to recognize the distinguished gentleman from Illinois, Mr. Rush, for his opening statement.
I want to thank you, Mr. Chairman, and I also want to extend my compliments to the acting Assistant Administrator, Ms. McCabe. I want to welcome you again to this committee, subcommittee hearing. Mr. Chairman, I want to also thank you for holding this hearing today on what you have called the Ratepayer Protection Act of 2015. Mr. Chairman, a more appropriate and fitting title for this legislation before us would be the Just Say No to the Clean Power Plan Act, which is a fitting description of what this legislation attempts to do. The bill seeks to delay and ultimately get rid of the Clean Power Plan by extending all compliance deadlines until all legal challenges are decided by the court. Here we go again. Under this legislation, the time period for all Clean Power Plan compliance and submission deadlines would be extended until 60 days after the final rule appears in the Federal Register, and only after, and I quote, judgment becomes final and no longer subject to further appeal or review, end of quote. When is that supposed to happen, Mr. Chairman? That's the question. Again, to delay is to deny. And this certainly is the Just Say No bill. Just Say No to the Clean Power Plan Act. Mr. Chairman, at first glance, this bill, the purposes of this bill and language may seem innocuous. And in fact, what this bill actually do is unnecessarily stall and delay implementation of the Clean Power Plan, and also it will spur countless and in most cases frivolous and meritless challenges to the plan in order to extend the ultimate compliance time. Just say no. To delay is to deny. Another problem with this legislation is that it will effectively give governors veto power over the federal requirements of the Clean Power Plan if they decide that uh, their states don't want to do this, don't want to cooperate, don't want to comply with the plan, and that the plan would have an adverse effect on either the state's ratepayers or the reliability of its electricity system. Unfortunately, Mr. Chairman, allowing governors to join in this attempt to just say no to the Clean Power Plan will fly in the face of decades of the Clean Air Act's use of cooperative federalism, which has been so successful in moving our nation forward in protecting our air and protecting our environment. Additionally, Mr. Chairman, there is no need to provide a safe harbor for states who cannot or will not forward plans to bring their states into compliance with the Clean Power Plan, as this bill attempts to do, because already under current law, the EPA sets the emission reduction goals under Section 111D, and it is up to the states themselves to decide how to best achieve these reductions. However, Section 111D states that if states refuse to present a plan that will reduce carbon emissions from existing power plants, then the EPA, the good old EPA, will step in with a federal 111D plan to ensure that these environmental risks are addressed to the benefit of this nation as a whole. Mr. Chairman, it would indeed set a dangerous precedent to both the Clean Air Act and to the overall public health if Congress were to enact a law that would allow 50 governors to simply veto federal environmental policy that they did not like or that they do not agree with. The Clean Air Act's use of cooperative federalism has been a cornerstone in moving our nation forward in its environmental protection policies. And this bill has the potential, the stark potential, to undo decades worth of progress that we have seen and witnessed in this area. The provisions in this bill will make it too easy for a governor to just say no to reducing harmful emissions from power plants, the number one emitters of carbon dioxide, if they found that these regulations would be too burdensome to act. Mr. Chairman, I think we should think long and hard, consider what we're doing before we can go down this slippery slope and give individual states the power to turn back the clocks to the dark days on what we have been so very successful so far in terms of our environmental protection policies. Mr. Chairman, this is a bill that, frankly, doesn't really deserve our time because this bill is so inappropriate on its face. And I thank you, and I yield back the balance of my time.
The gentleman doesn't have any time, but thank you for your comments. And at this time, I'd like to recognize the chairman of the full committee, Mr. Upton, for 5 minutes.
Well, thank you, Mr. Chairman. I want to thank the witnesses and appreciate their input regarding the administration's controversial Clean Power Plan. No less an expert than Lawrence Tribe has testified that this proposed rule exceeds EPA's statutory authority and raises numerous constitutional issues. In addition, more than half the states have questioned the legality and feasibility of EPA's attempt to micromanage each state's electricity generation, transmission, distribution, and use. So if you think of the Clean Power Plan as the Obamacare approach applied to state electricity systems, you would not be very far off the track. Like the health law, the costs of the Clean Power Plan ultimately fall on consumers and job creators who are certain to see their electric bills go up, and for many states, the rate increases will be indeed significant. As highlighted in Mr. Triscoe's testimony, Michigan residents can expect rate increases up to 15%. This would come at the worst possible time as folks are starting to get back on their feet. Rate hikes will impose unwelcome hardships on family budgets, inflict damages to businesses both large and small, hamper job growth, and impact certainly the most vulnerable. The Ratepayers Protection Act's reasonable and targeted provisions will greatly reduce the major risks to ratepayers from the administration's plan. First, the bill extends the compliance deadlines until after judicial review is completed. Given that so many states have raised serious concerns about the legality of EPA's proposed rule, and a dozen have already sued, it makes sense to clear things up legally before the rule's costly and complex requirements take effect. The Ratepayers Protection Act also provides each state governor with the authority to protect its ratepayers to the extent a state or federal plan under the rule would have a significant adverse effect by contributing to higher electric costs or threatening reliability. States, not the EPA, should have the last word with respect to the affordability and reliability of their electricity systems. On the other hand, those state governors who are supporting EPA's proposed rulemaking and no problems with it are free to comply with the agency's demand. Go right ahead. In northern states like Michigan, affordable and reliable electricity is absolutely essential to making it through the winter months. And America's manufacturing sector could not survive without electricity rates that allow it to be globally competitive. In fact, the National Association of Manufacturers has warned that higher costs as a result of the Clean Power Plan and other recent EPA rules could place domestic manufacturers at a global disadvantage. That's real. The common sense protections in the Ratepayer Protection Act are critical to preserving both our standard of living and our economic future. In making these decisions, governors must consult with their state's energy, economic, health, and environmental authorities. States can and should be a necessary check on EPA's otherwise one-sided authority to change the state's electricity system and to do so without regard to the consequences. This bill, the Ratepayer Protection Act, is a sensible approach to addressing the very serious problems with the administration's plan. Washington certainly does not always know best, and I would urge my colleagues to join the effort on behalf of jobs in affordable energy, and I yield back the balance of my time.
Gentleman yields back. At this time, I'd like to recognize the gentleman from New Jersey, the ranking member of the full committee, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. Today's hearing on a bill to gut the President's Clean Power Plan is misguided and unfortunate. I do not support this legislation and urge members to closely examine its harmful effects on our country's progress to combat damaging pollution and catastrophic climate change. First, let me thank the Assistant Administrator McCabe for being here today. I understand that EPA received over 4 million comments on the proposed Clean Power Plan, and that you, Administrator McCarthy, and the agency staff are working day and night to review and consider those comments. EPA did an unprecedented amount of outreach to states, industry, and stakeholders when developing the proposal, and the agency has continued its outreach. This includes an ongoing series of listening sessions with the Federal Energy Regulatory Commission, and EPA is also actively working with states, grid operators, public utility commissions, and electricity suppliers of all kinds to finalize a rule that works for everyone, especially ratepayers. Like all proposed rules, the agency is considering adjustments to the Clean Power Plan based on comments and stakeholder feedback. For example, the draft rules implementation timeline won't begin until 2020, but because of feedback, EPA is considering modifications to allow additional flexibility to states to help address questions of timing, reliability, and other implementation issues. And for that reason, I believe the Clean Power Plan is eminently reasonable and achievable, and EPA is clearly committed to an open dialogue to ensure its success. Meanwhile, the bill before us seeks to undermine all that work. Under the current Clean Air Act and the proposed Clean Power Plan, no state has to submit a state plan. So giving governors the option to opt out of developing state plan doesn't change anything. However, and this is important, this bill would give governors the option to opt out of a federal plan which EPA must implement if a state fails to act. In that respect, we should view this bill for what it really is, an amendment to the Clean Air Act, which would overturn the principle of cooperative federalism that has been in place for more than 40 years. This cooperation is essential to ensure all Americans are protected from environmental harm, even if the actions of their home state fall short. Under this bill, large sources of carbon pollution could be exempt from any meaningful restrictions, and therefore bad states get a free ride to pollute without any consequences, while every other state foots the bill. Finally, this bill would automatically delay implementation of the Clean Power Plan by extending all deadlines by the amount of time it takes litigation to conclude. That blanket extension would be given to all polluters, regardless of whether their legal arguments turn out to have any merit. As we heard at our last hearing, EPA does in fact have authority for the Clean Power Plan and will ultimately be upheld by the courts. But this bill would provide an incentive for polluters to run the clock on litigation, so all deadlines in the rule would be extended as long as possible, no matter how frivolous the challenge and regardless of the outcome. And this is an incredibly reckless and dangerous precedent to set with regard to any law, in my opinion. I think the Republicans they refuse to accept the fact that climate change is real and that Congress should be taking action to address it. The effort by Republicans on this committee to push states to say no and refuse to cooperate with EPA is reckless and dangerous. The New York Times referred to it as quote, a travesty of responsible leadership. Meanwhile, former Bush EPA administrator and New Jersey Republican, I stress Republican governor, Christine Todd Whitman, characterized this effort as having, quote, the possibility to undermine our nation's entire rule of law. States should begin the careful process of moving to cleaner, cheaper, and more reliable electric power systems. The Clean Power Plan is a modest and flexible proposal. If my Republican colleagues have a better idea for protecting against a changing climate, then please speak up. Just saying no and condemning future generations is not an option. And I don't know if anybody else wanted to have a minute left on our side. If not, Mr. Chairman, I yield back.
Chairman yields back, and that concludes the opening statement. So at this time, I'd like to formally introduce Ms. Janet McCabe, who's the Acting Assistant Administrator for the Office of Air and Radiation at the EPA. And once again, welcome, Ms. McCabe, and I'd like to recognize you for 5 minutes for your statement.
Thank you, Chairman Woodfield, Ranking Member Rush, and members of the subcommittee. I appreciate the opportunity to testify before you today on EPA's proposed 111D rule for existing power plants, also known as the Clean Power Plan, and the discussion draft of the Ratepayer Protection Act of 2015. The discussion draft and EPA's proposed carbon pollution plan reflect a shared concern, maintaining the reliability of the electricity grid. Clean Air Act regulations have not caused the lights to go out in the past, and the proposed Clean Power Plan will not cause them to go out in the future. This morning, I'll talk about EPA's proposal and how the final rule will address many of our shared concerns. And my written testimony provides additional feedback regarding the discussion draft. To summarize, EPA views the draft as premature because EPA has not yet finalized the Clean Power Plan, unnecessary because EPA has the tools and indeed the obligation to address cost and reliability issues in our final rule, and ultimately harmful because the bill, if enacted, would delay or prevent the climate and air quality benefits of the Clean Power Plan. This summer, EPA will be finalizing a flexible, common-sense program to reduce carbon pollution from the power sector, the largest stationary source of CO2 emissions in the country, while continuing to ensure that all Americans have access to affordable, reliable energy and a clean and healthy environment. Over EPA's long history developing Clean Air Act pollution standards for the electric power sector, including the proposed Clean Power Plan, the agency has consistently treated electricity system reliability as absolutely essential. We've devoted significant attention to this issue ourselves and have also made sure that we were working with stakeholders and energy regulators at the federal, state, and regional levels to ensure that the important public health and environmental protections Congress has called for are achieved without interfering with the country's reliable and affordable supply of electricity. In crafting the Clean Power Plan proposal, EPA sought to provide a range of flexibilities and a timeline for states, tribes, and territories and affected generators that would reduce carbon emissions while maintaining affordable electric power and safeguarding system reliability. EPA's proposed plan gives states the opportunity to choose and allows electric generators to choose from a wide variety of approaches to cutting emissions, and is intended to provide states, generators, and other entities charged with ensuring electric liability with the time they need to plan for and address any reliability issues they believe may arise. This same wide range of approaches also provides states and utilities with the latitude they need to minimize costs. Thanks to both our extended engagement process and the many substantive comments we received, we know that many states and power companies are urging us to consider changes in order to ensure that the final rule delivers on the significant flexibilities we intend to create to protect system reliability and affordability. This public process has provided a tremendous amount of information and ideas, and I assure you that EPA is taking all of that information and those suggestions that comments have provided very seriously, and we expect to make changes to the proposal to address many of the suggestions and concerns we've received. Ideas offered by stakeholders range from ensuring that initial compliance expectations and compliance flexibilities provide the states the latitude they need to establish workable glide paths that do not put reliability at risk, to addressing concerns regarding stranded assets, to facilitating workable regional approaches that are not too formal or too complicated to implement easily, and to crafting what many are calling a reliability safety valve as a backstop in case a reliability issue does arise. EPA has taken unprecedented steps to reach out to and engage with all of the states and our stakeholders. One of the key inputs EPA heard before proposal and during the comment period is the need to design the rule in a way that respects both the urgency of dealing with climate change and the time it takes to plan and invest in the electricity sector in ways that ensure both reliability and affordability going forward. We've paid close attention to those comments and will finalize a rule that takes them all into account. I look forward to your questions, Mr. Chairman. Thank you very much.
Well, thank you very much, and we appreciate that statement. And at this time, I'd like to recognize myself for 5 minutes questions. Ms. McCabe, I think even you would agree that this is a bold move on EPA's part. We all understand 111D and the controversy surrounding it, and that such a ubiquitous substance as CO2, you all have never tried to regulate anything like that under 111D before. And I will tell you, as I said in my statement, half the state regulators have been in touch with us, and they're very much concerned, and you know the lawsuits have been filed. So I think you would acknowledge that this is a very bold move on EPA's part. And one of the things that I'm concerned about, and I would like to make very clear, I'm certainly not an expert in the Clean Air Act, but I've read more than I want to be truthful about it. But there is a definition in the Clean Air Act about a source, and I don't think that a state has ever been considered a source before. And every time I hear Ms. McCarthy or anyone from the EPA or from the administration talk about this rule, they go to great lengths talking about all the flexibility that are given to the states. But the states have no flexibility in determining what the cap will be on the CO2 emission. Isn't that correct? Do they have any option on what the cap will be?
EPA will set the target.
Yeah, EPA sets the target. Mm-hmm. And how did EPA set the target for each state?
We looked at a wealth of data about power generation across the country, looking at the kinds of technologies that are already in use.
And how did you decide what the number would be for each state?
We looked at 4 particular types of approaches that are widely in use across the country, and we applied those in a uniform manner to each state's power inventory.
And did you assume that every coal plant, for example, would be able to become more efficient?
We used information from across the country to apply an average expectation about efficiency improvement.
And what is that average expectation?
In the proposal, we assumed a 6% efficient.
And you know what? We're hearing from everyone that many of these coal plants, there's no way they can get a 6% more efficient rating. So, and people are questioning about this assumption, how you came up with this 6% assumption. But let me just ask you, this legislation has been characterized as unreasonable. When you consider the unique and radical approach that's being utilized with this rule, why would anyone object when we already know many lawsuits have already been filed? Once that rule becomes final, there's going to be more lawsuits filed. Why would anyone, when it's already been said that this is not going to significantly affect the climate anyway, why would anyone object to giving states an opportunity to do their state implementation plan after the judicial remedies have been exhausted?
Well, I have a couple of responses to that, Mr. Chairman, and you won't be surprised to hear that I don't exactly agree with some of the words that you've used to characterize the plan. It's not radical. It follows the process laid out.
Has 111D ever been used in this way before?
111D has been used to establish expectations that states then...
But you've only utilized it 4 or 5 times in the history of the Clean Air Act, and it's always been very focused, small type of arrangements. But anyway, why would you object to giving states an opportunity to exhaust legal remedies before they have to give a state implementation plan?
Well, there is a system in place for legal concerns, if there are any, about a rule that EPA adopts under the Clean Air Act to test out those legal concerns, and that is the legal
okay, but
challenge
why would you
process.
object? I mean, why do you object to giving states this additional time?
The discussion draft basically allows an unlimited time. This could lead to an unlimited delay in the amount of time that would go by before steps would be taken to implement.
Well, we've been told that normally that it's not unusual for states to be given 3 years for implementation plans, but in this instance, they're getting like 13 months or even less.
No, that's not correct, Mr. Chairman. The implementation period for this rule goes out to 2030.
I'm not talking about implementation. I'm talking about the plan, submitting the plan.
Well, that's right.
And that is a major chore. My time's expired. At this time, I recognize the gentleman from Illinois, Mr. Rush.
Want to thank you, Mr. Chairman, again, and Madam Administrator. One of the foremost beneficiaries of the CPC is low-income communities, and I have a special and particular interest in the low-income communities. And are you aware of the NRDC report that just came out?
Yes, I am.
That report stated that low-income Americans, again, will benefit most from the CPP. Do you have any commentary on that, and what's your thoughts about that?
Well, we know that the impacts of climate change that we're already experiencing in the country and that we can expect to experience more can have an especially impactful effect on low-income communities who are already at a disadvantage when it comes to the impacts of pollution. We expect and we're seeing that climate change will lead to more heat waves, more air pollution, which will exacerbate asthma. Low-income communities often have higher rates of asthma. Disruptions such as from the increased intensity of intense storm events can have an adverse impact on low-income communities that are not in a position to recover as easily as others with more means. So we definitely see that low-income communities are more at risk of the adverse impacts that we see on public health, welfare, and economic well-being, and will benefit significantly from steps that we can take here.
And do you agree that states have a responsibility to promote the general health and welfare of low-income communities, low-income individuals, and that there is a way for the states to both invest in cleaner, more efficient energy measures, such as the CPP and what it proposes, and also provide help to those most vulnerable communities through energy efficiency measures and direct bill assistance. Do you agree with that?
Well, the Clean Power Plan and our proposal would allow states all the latitude they need to design a plan that meets the needs of all the communities in their state and provide protections to low-income communities to make sure that the benefits of the program are realized for all citizens across the state.
Yeah. Madam Assistant Secretary, if this bill passes and becomes law, the bill under consideration, what would be the result in your estimation? What would be the outcomes? What kind of impact would this bill have on the EPA's stated goal and of protecting our environment? What would be the
Well, it would clearly delay the reductions that are to be achieved through this program and that so many people see as necessary. In fact, many Americans see as necessary and are asking EPA to take action. It would create additional uncertainty. And one of the things that we always hear from the power sector is that certainty is one of the most important things for them to be able to plan for how they're going to manage their resources in the future, knowing that carbon reduction is on the way, and so they want to know and get on with it. And the bill also would create an opportunity, as you've identified, for governors to basically opt out of the program, which is completely inconsistent with the way Congress set up the Clean Air Act, which is that the federal government sets the expectations for what a clean and healthy environment should be across the country, and then states use their flexibilities to achieve those goals in the way that works best for them.
And would you agree that if this bill passes, then the Congress would be playing a sort of an environmental Russian roulette in terms of the health and welfare of our nation and its citizens, particularly as it relates to the environment?
Well, it would be a concern for there to be a delay in a reasonable and common sense program to make these reductions.
Right, one state might get it right, one state might get it wrong, the next state might get it in between, so we're playing some kind of a hide and seek game with our citizens and the environment. Would you agree with that?
I think you've raised real concerns.
Thank you. Mr. Chairman, I yield back.
Gentleman yields back. This time recognize the gentleman from Texas, Mr. Olson, 5 minutes.
I thank the chair, and good morning, Administrator McCabe.
Morning.
I'd like to start by reading a couple quotes from the Public Utility Commission back home. It's called the PUC, and they help run one of the largest states in America. Texas has almost 10% of this country's population, and we have an enormous portion of America's energy production and its busiest port in Houston. Again, these quotes aren't from a coal lobbyist. They're from a commission that helps keep the lights on and keeps rates fair. And I quote, "Rule 111D will create significant electric reliability problems in Texas." End quote. Another quote, "The carbon emission limits for Texas will result in significantly increased costs for Texas electricity consumers." End quote. The final quote, "It will cause," another quote, "increased energy costs for consumers up to 20% in 2020," end quote. That doesn't include new transmission lines and new power plants. The cost will hit, and this is their quote, 10 to 15 billion in annual compliance costs by 2030. I know you think this rule has plenty of flexibility. Others disagree. Recently, FERC Commissioner Mueller has said that the rule would mean havoc on the grid if there isn't a reliability safety valve. The operators want an automatic way to react if reliability is threatened too. My question is, can you commit right here to putting a relief mechanism to protect reliability or even affordability in the final rule? If no, why not? What's the harm?
Well, you've raised concerns that, as I mentioned in my testimony, we have as well, and we always do. We've received many comments from across the country, including your state of Texas, raising these issues with a lot of good ideas. And as Administrator McCarthy and I have said on many occasions, we do expect to make some changes in the rule that will address a lot of these concerns, including considering a variety of ideas that people have suggested to us for things like a reliability safety valve. So I think when the final rule comes out, you will see that we've been very responsive to these concerns.
But a safety valve, yes or no? Yes or no?
You know, the administrator signs the final rule, so I can't commit her here, but I will tell you that these are the kinds of things that we're looking at very closely.
So it looks like a sort of sideways, not yes or no. Next question is about small power systems. There are dozens of power systems across utilities across the state of Texas run by municipal cities. We have them all across America, actually. These communities have come together to build one or two efficient little power plants to keep the lights on. For example, back home in Texas, the Texas Municipal Power Authority has one small coal-fired plant that provides power for 4 cities: Denton, Bryan, Garland, and Greenville, north central Texas. They don't have backup gas plants to take up the slack or inefficiencies to fix. They told the EPA recently that their best bet to comply might be just to shut the power plants down, just close it down. They rely on this power for affordable power. The impact to the economy will be severe. There are stranded investments made to power directly to these towns. Won't your rule have an impact on small, self-reliant communities like Denton, Bryan, Garland, Greenville, all across America? We heard these communities, ma'am?
Yeah, Congressman, we've spent a lot of time with small municipal providers and rural electrics, and we've heard their concerns. I think comments like that, though, don't take into account the flexibility that the states will have to design plans that address concerns like that. There is nothing in the rule that requires any single plant to do any particular thing. And there's lots of opportunities for the state of Texas and every state across the country to design a plan that makes sure that they are paying attention to the particular needs of the particular types of power providers in their state.
But they've reviewed the rules and say the best bet may be just to close down. I mean, that's a real problem, ma'am. Have you considered that they'll just close down because of these new rules? As part of the equation going forward, what do you do to fix this problem?
The decision to close a plant is made on the basis of a lot of considerations that go way beyond environmental regulation. But what I'm saying is that the plan does not put any state in the position of having to make that particular choice on behalf of a particular company. There are options that they can build into their plan to avoid those situations if that is in the best interest of those companies and the customers that they serve.
Well, the folks back home disagree. I yield back the balance of my time.
This time I recognize the gentlelady from California, Ms. Capps, for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing, and I thank Ms. McCabe for your testimony. And as we know, the science is clear that increased concentrations of carbon dioxide and other greenhouse gases are causing our planet's climate to change. Climate change affects our daily lives by increasing health risks, making our oceans more acidic, threatening food and water supplies, exacerbating drought, among many other impacts. And these impacts are predicted to only intensify in the future, negatively impacting our children and grandchildren. And that's why we all have a responsibility to act now to reduce the carbon emissions and other greenhouse gases that are driving climate change. As you know, power generation was responsible for nearly 40% of the carbon dioxide emitted last year in the United States. Of this, 76% was from the coal power sector. The simple truth is that we cannot address climate change without reducing these emissions. That is what EPA is doing with the Clean Power Plan. The plan is strong, yet flexible, allowing each state to determine the best ways to achieve its carbon dioxide targets. And EPA is in the process of reviewing public comments to ensure that the Clean Power Plan will meet its goals, minimize cost and reliability concerns, and maximize benefits to human health and the environment. Ms. McCabe, can you elaborate on the flexibility that states have? And just tell us what that, some examples or what that means the states have in meeting the carbon reduction targets and the process EPA has used to develop this kind of plan.
I'd be happy to, Congresswoman. So there are a number of ways we built flexibility into the plan. First of all, as I've said already, there's no prescribed approach or control technology that states or companies have to use. We identified 4, but there are many other ways that companies can go about reducing carbon. Including really positive community building things like investing in renewable energy and energy efficiency. Another flexibility in the plan is the length of the time to implement it. So all the way until 2030, states and utilities would have to plan. So that builds in a lot of flexibility right there. This is also not a rule. Some environmental rules have an hourly emission rate that companies are required to meet. This will not have that. It will have an annual type of approach averaged over the year, which means that if utilities need to have variation in their emission rates over the course of the year, they'll be able to do that and still meet this, because for carbon, that makes sense. Another flexibility we built into the rule was allowing states to join together with other states in regional plans, which even opens up the flexibility even more. And we've had a lot of interest from states in that, especially in our looking at more informal and less complicated ways that they could join up with one another or with other states.
Thank you. You know, we've entrusted EPA and this process with promoting and protecting clean air now for over 40 years. They have consistently performed well. Since 1970, EPA has cut many dangerous air pollutants by 90% or more. I think we lose sight of that amazing fact. And our economy at the same time has tripled in size. So here's another question. Do you think EPA would have had this much success protecting clean air and public health if states had been allowed to opt out of EPA regulations that they didn't like over this long history?
It has been absolutely essential that the way Congress set up the Clean Air Act has worked for EPA to set those national targets, and then every state to step up and do their part. And as you recognize, air pollution doesn't respect state boundaries.
Absolutely. Just one, see if we can get this question in. As you know, the discussion draft before us would not only allow states to simply opt out of the Clean Power Plan if they don't want to participate, it would also delay implementation of the plan indefinitely until every lawsuit has been litigated. Ms. McCabe, is climate change an urgent problem or one that can wait indefinitely to be addressed?
Climate change, as is being emphasized by scientists almost every day now, is something that we must pay attention to and begin our work on now.
Thank you. And I had one question. I'll just put it out if you have time to address it. Ms. McCabe, what are some of the benefits that would likely be denied to our constituents if this bill became law?
Well, this is part of a large effort, a global effort to address climate. This is a very significant part of that. If we don't pay attention to the increasing levels of carbon, we will see increasing weather events, air pollution, droughts, and all of the health and welfare impacts that come along with those sorts of impacts.
Thank you very much.
This time I recognize the gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. McCabe, for appearing here. I've got 3 questions, if I can get to them kind of quickly with this. Representatives of FERC in 2014 made a statement, and I was just calling up on my computer, my little phone here, to find out what that statement was again. They said, because your response earlier was you seem to discount the reliability by this, is what I heard, was the grid is going to be fine under this rule. But what they went on to say, FERC said that they worried that the electric grid doesn't have the infrastructure to replace the retiring coal and nuclear plants, saying some U.S. regions would be subject to rolling blackouts due to this deficiency by the year 2017. Do you agree with what FERC is concerned about?
I think we all want to make sure that.
It's just a yes or no. I've got 3 I'm trying to get to.
No, I do not agree with that.
You don't agree with that statement? Okay, thank you. The second is that Mr. Pallone said that, and I appreciate his remark, but he used a term, he said they're bad states out there. Maybe West Virginia would be considered a bad state in his eyes because 98% of the power that we generate, that we consume West Virginia, it comes from coal. So I'm curious on this concept that you're coming up with. What's the cap going to be in West Virginia, and what's the alternative that we have? If we burn coal, what are we supposed to do?
Yeah, so the proposal was designed to accommodate states that burn a lot of coal and states that don't. I come from Indiana. It is also a state that burns predominantly coal. And when
Well, it says you were to change the heat rate. One of your blocks says change the heat rate, but yet there's no increased funding under NETO or other groups to be able to do that research to be able to accomplish it. So I'm really concerned it's a dream. It's just an ideological dream because I don't see how they're going to cut back. But please, if you could, what is the cap? What's the change in West Virginia? Do you have a proposed idea what you want to do in the CO2?
I can't tell you now what
Could
changes.
you get back to me on that?
Well, in the final rule, we will reflect all the changes that
So
we'll
the
make.
prior to the final rule, how are people going to respond to that if they don't know what the effect it could have on a state like West Virginia?
Well, states like West Virginia and others have given us lots of input suggesting ways in which we ought to adjust their targets.
Okay, so you don't have a plan. Let's go to the third question, and I was reading the testimony of the next panel, and that there are increases in residential electric costs associated with this act. It will be assessed at the context of the long-term declining trend of real income among American families. And Congressman Rush from Illinois made a good point, and he's concerned about low-income families. But low-income families, households have lost 13% of their income between 2001 and 2013. 13% of low-income families are going to struggle with this as a result of this. So my concerns are with this, we're going to spend $7.5 to $8.8 billion perhaps to be in compliance. It's going to be passed on to the ratepayers. What am I supposed to tell Mildred Schmidt, who lives next door to you or lives next door to me? How is she going to deal with this issue?
Well, given the reliance of the way the industry is going in terms of employing energy efficiency, we lay out that our proposal will lead to lower energy bills by 2030. So energy bills will go down. And that information is available for everybody
I
to
want to
look
make sure
at.
I hear it. You said energy prices are going to go down?
Energy bills will go down, Congressman.
How in the world are they going to go down if
Because
we're
people-
spending this
with,
much more?
with energy efficiency, people will be buying less electricity.
And you're serious? You really
I am.
believe this?
I do. We're seeing it all across the country. We're seeing it in places like New England that have been very aggressive on energy efficiency. If we use less energy, our bills can go down, and our carbon emissions can go down.
So let me make sure it's clear. You're testifying here before us that by the time this thing's fully implemented, that the rate base or the consumers are going to be paying less electric bills as a result of having this draconian standard forced upon them.
That is what our analysis shows across
But
the country.
do you believe it yourself that it's Mildred Schmidt is going to be paying less for electric bill?
I believe that if we get serious about energy efficiency and managing our use of electricity, that can lead to lower energy costs.
Unbelievable. It just seems delusional. Thank you very much.
I may just make one comment. The Energy Information Agency just released a report showing that electricity rates for the country between 2014 and 2015 have gone up for the entire country. At this time, I'd like to recognize the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman and Ranking Member, for holding the hearing. The EPA's Clean Power Plan has been subject to much debate. The Supreme Court's consistently agreed that EPA has the authority to regulate greenhouse gases, so the legal challenges facing the Clean Power Plan are very interesting. I've been in Congress for some time, and since I joined the House, worked extensively on trying to pass common sense environmental legislation. Unfortunately, we haven't done that in the last few years. We need to work together to address the issues of carbon emissions, and that doesn't mean eliminating certain fuels, and it certainly doesn't mean eliminating the EPA. We need to represent our constituents to find that acceptable compromise. I want to thank the EPA because we just learned that the partnership of the input you're getting from Federal Energy Regulatory Commission on the reliability issue, that's one of the concerns we have. Of course, if there's a reliability issue, there could also impact the prices because of some of our markets are competitive. So in the EPA, at least in the release I saw, understands they don't understand reliability, but FERC does. And so we want to make sure whatever you do does not cause reliability issues in our communities. Recently, you and Administrator McCarthy were indicating willingness to address issues with interim deadlines of the CPP. I've repeatedly supported efforts to implement rule changes with timelines that allow industry time to adjust to protect for reliability. It's important for the sake of our economy, electricity reliability, and workforce that we give ample time to implement the new rules. What types of comments did EPA receive regarding the interim goals that led the agency to make these statements?
Yeah, that is an issue that we got a lot of comment on, Congressman, and just to make sure everybody knows, the ultimate compliance deadline for the rule is 2030, but the proposal had an interim goal that would operate between 2020 and 2029. And we heard from some states that posed a very substantial reduction on them early in the process. Our intent was to make sure that progress was being made in this run-up to 2030, but in a way that could be moderately metered in a way so that reasonable choices could be made. So we've heard all the way from don't have any interim targets to other sorts of ideas about how to adjust those. But primarily the issue has been don't have it so that any one state has a significant initial reduction that they have to make as quickly as 2020.
Would interim relief provide states enough time to draft state implementation plans and receive guidance from EPA?
Oh, certainly, and we're already gearing up to provide states with guidance and information on how to put their plans together.
Does EPA believe that concrete monitoring requirements and performance metrics would accomplish the same goals as a clean power plan, but allow the states to tailor a path to 2030?
Well, the plan would allow the states complete latitude to design plans that make sense for them.
Obviously, the large-scale reduction is challenging, especially when addressed at the last few percentage points. Does EPA's Clean Power Plan include graduation dates to accommodate the state's efforts to reduce emissions? Do they get credit over a period of the 10 years to 2030?
Yeah, sure. I mean, they work their way down to that final timeline. And I should note, too, that as has always been the case with state implementation plans on air quality, there's opportunities along the way to make adjustments if needed.
What does EPA think about the reliability safety valve, where states requiring compliance flexibility to address reliability issues would have FERC sign off on the nature of the reliability problem? Do you think that would be workable?
We think there are a number of good ideas about how to manage something like a reliability safety valve. You know, we employed something like that in the mercury and air toxics rule that has turned out to not be needed by very many people at all, but it was good to have it there as a backstop, and we're in good discussions with FERC about the options there.
So we're not reinventing the wheel here that was used before and could be used again here in this situation?
That kind of approach was used before, that's right.
Okay. Thank you, Mr. Chairman. I yield back.
This time, recognize the gentleman from Pennsylvania, Mr. Pitts. Mr. Barton for Texas, 5 minutes.
I'm willing to let Mr. Pitts go if he's okay. Well, thank you, Mr. Chairman. Thank you, Mr. Pitts. Thank you, Ms. McCabe, Honorable McCabe, for being here. I've got a few comments I want to make, and then I've got several questions. My first comment is that there's absolutely no health benefit to this proposed rule. EPA's primary responsibility is to protect the public health, and the Clean Air Act gives the EPA wide authority and wide latitude in order to do that. It's one of the few federal agencies that has the authority to set a rule without any real consequences being looked at in terms of a cost benefit if the administrator thinks that it's in the public interest to protect the public health. But this particular rule has no health benefit at all. What it is a politically correct social policy. Now, that may be acceptable, it may not be, but this is not a health-based rule. It's not a rule based on real economic science, nor is it required by any existing federal law. There's no federal mandate in statute right now that requires this rule to be set. Again, it is simply the Obama administration deciding what's politically correct social policy, and they are hoisting it on the states to comply. I don't think it's going to actually be implemented. I think the courts are going to strike it down. But if it were to be implemented, or attempted in a serious way to be implemented under the current timelines in the proposed rule, the only certainty would be that electricity rates would go up, reliability would go down, and there would be routinely blackouts in many parts of the country. As you know, Madam Administrator, we had a blackout here in Washington, D.C. Not too long ago, a temporary blackout. As you also know, we had a coal-fired power plant in Virginia that was on standby and was shut down not too many years ago. If that power plant had still been online, there wouldn't have been a blackout. Now, I don't travel much internationally, but I do travel some, and there are parts of the world where it is a given that there is not 100% electricity reliability, and people plan for it. Fortunately, we don't have to do that here in the United States, but if this rule were to actually be implemented, that would become an occurrence that would not be unusual. Now, my first question to you is, what does the EPA consider to be an acceptable price for electricity for the average retail consumer per kilowatt hours?
I don't have an answer to that, Congressman. We work.
You don't have an answer?
We work with the energy regulators. That's a significant issue that is not within EPA's jurisdiction. What we do is we look at expected impacts on.
Well,
prices.
do you accept that if you shut down 30% approximately of the coal-fired generation capacity in the United States, that there's going to be an adverse price impact because of that?
Well, I don't believe that our proposal predicts anywhere near that kind of impact.
Okay,
And
what
I
does
be- and I
in
believe-
your what do you say it? The studies I've shown indicate that, but I'm not as aware of all the studies. What's the official EPA impact? What percent of the coal-fired power generation is going to be shut down if this is implemented as EPA projects it to be?
Well, let me emphasize again that there are lots of reasons why power plants shut down.
Well, why don't you just answer my question?
In the
EPA certainly has some projection about what percentage of the coal-fired capacity in the United States for electricity generation is going to be shut down.
in our
I'm told it's 20 to 30%.
in our regulatory impact analysis, if I remember correctly, and I'll confirm this for you, I believe that we projected that about 10% of coal plants would become uneconomical. Keeping in mind that
Could you provide that to the committee, because that's about half of the most benign economic study that I've seen. I'm not saying you're wrong. I'm just saying it seems to be overly benign.
We'll confirm that for you, but that's a reflection of the flexibility and the time that's allowed in this plan, and the fact that the average age of the coal-fired fleet in this country is
Well,
about
my
43
time has
years
already
old.
expired. Let me ask one. Do you think it's fair that one state, i.e. my state, the state of Texas, by itself has to have 20% of the reductions for the whole country?
The state of Texas has significant carbon emissions because of its size and the amount of power that's produced there.
So
this rule,
the Obama administration is just telling Texas to go jump in a lake. We don't care about your economy.
Gentleman's
no,
time's
sir, no,
expired.
not at all.
This time, I'd like to recognize the gentleman from Pennsylvania, Mr. Doyle, for 5 minutes.
Thank you, Mr. Chairman, and welcome. Administrator McCabe, a lot of people were speculating about the impact the rule's going to have on reliability of the grid, and we know it's a very elaborate and complicated machine. I'm not sure there's any way to actually know the impact until the states all submit and implement their respective plans, and because the grid is so interconnected, and you expect 50 different state plans. Can you talk about the administration's plan to ensure that all of these plans work together in a way that protects the reliability of the grid? Because we know energy production and consumption isn't always limited by state lines.
Yeah, so there are a couple of good points that you raise. One is that we don't know what the state plans will look like. And so a lot of the predictions about things that will or won't happen are based on people not knowing what choices states will make. The other is that, as you've pointed out, it is an interconnected system. In fact, many power companies themselves operate in multiple states. And what we're seeing, which is very positive, is lots of conversations happening both between the energy regulators and the environmental regulators, and also between the power companies and the state governments across state lines in regions, talking about ways that they can work together, how states can set up their plans so that they can interconnect with each other in ways that make that sort of either averaging or working together across companies, across states, very easy to do. And all of those things will help make sure that power is where it needs to be, when it needs to be, over this long trajectory of implementation.
Let me ask you about how this proposed rule treats nuclear power, specifically existing plants, which we have in Pennsylvania. It's, as you know, our only source of reliable baseload electricity that's carbon-free. But my understanding is the proposed rule gives states little credit for preserving plants in the nuclear fleet, approximately a 6% credit. Is EPA reconsidering how it treats existing nuclear power plants in its rule? It seems to me that any nuclear power plant whose operator makes the significant investment to pursue relicensing during the compliance period, that should be treated as new capacity. And I say that because there's no guarantee that the NRC would grant such a license, and it's far from assured that plant operators will make the commitment and spend the money to pursue relicensing when many of these plants are already financially challenged. So it just seems to me if we start to lose a large chunk of our nuclear fleet, I don't see how we're going to meet our greenhouse gas goals. Yeah. So how are you going to treat the existing plants?
That's a very good point, and we did receive a lot of input on how we proposed to handle nuclear plants. So we're thinking very hard about that. Our intent certainly is not to put any barriers in the way of continued use of nuclear power, seeking relicensing, upgrading if that's appropriate, plants that are under construction going forward. We also recognize some of the challenges that industry is facing today, and we don't want the Clean Power Plan to interfere with the use of that power. So we're looking at all of that, Congressman, and we'll be addressing that.
And are you considering looking at relicensing as new capacity?
We're looking hard at that issue and considering what our options are there.
I see. Also, I want to talk a little bit about the concerns people have of the impact on baseload power plants. You know, we can argue over the merits of this type of power, but for the time being and the foreseeable future, these are the plants that are providing the bulk power that we rely on. Are you concerned about the impact that closures on the grid, its operation, its ability to perform in severe circumstances? Has EPA conducted any load flow analysis to determine the impact on power flows and grid stability based on this rule?
As part of our proposal, we took a look forward. It's not a reliability analysis in the formal sense of the word, but we took a look into the future, and we're comfortable that what we were putting forward was a reasonable approach in order to preserve reliability. Coal would remain about 30% of the nation's power supply in 2030. So many of those baseload plants would become efficient and would continue to operate. There are lots of other organizations that are looking at these issues. The Federal Energy Regulatory Commission just held a series of 4 hearings that we attended and were very involved in. This is not EPA's area of expertise, so we know that we need to be communicating and working with the agencies whose expertise it is to make sure that we're doing this right.
Thank you. Mr. Chairman, thank you.
Thank you. This time I recognize the gentleman from Pennsylvania, Mr. Pitts, for 5 minutes. Who's next? The gentleman from Ohio, Mr. Latta, for 5 minutes.
Well, thank you, Mr. Chairman, and Administrator, thanks very much for being with us today. In the proposed Clean Power Plan, EPA estimates costs of between $5.5 billion to $8.8 billion every year for each of the years from 2020 through 2030. Are these costs over and above the costs associated with EPA's mercury and air toxics rule, which EPA estimates will cost about $9.6 billion annually in the coming years?
Those are costs associated with this program.
Let me ask, now, how did you come up with those estimates?
We used standard approaches guided by guidance from the Office of Management and Budget, working with our economists at EPA to make determinations about the expected costs and the benefits.
Okay. And, you know, just to follow up where Mr. Barton was with his questioning, has the EPA done an analysis of the cumulative effect on the electricity rates of all its recent major air rules affecting power plants?
No, we haven't.
You have not?
I don't believe we have.
Okay. Given the billions of dollars in new costs from these rules that have not yet been reflected in the rates, shouldn't the EPA producing a clear cumulative assessment for the public to review? And just to, you know, I know the folks on this committee have heard me say it before, but I represent a district with about 60,000 manufacturing jobs. I have a lot of my jobs out there are in plants that are really high users of electricity, and they keep these people working every day. But is there a clear cumulative assessment for the public to review out there from the EPA?
Well, there are many things that, of course, as you know, that go into the cost of electricity. And so EPA, as we're required to do, for each program, we look at the costs associated with that program, and each program before it has looked at the costs associated with that program.
And, you know, on the next panel, you might have already seen who's going to be testifying before us, but the next panel, we have some very powerful testimony about the impact of the higher rates on families with middle to lower incomes. And what assurances can we give these ratepayers in 31 states reviewed that they don't need to be concerned about higher electricity rates?
Well, I think as we've discussed already here this morning, there are a number of elements that go into this proposal and will go into the final rule that will give states flexibility to make sure that they're implementing this in a way that can protect especially lower income ratepayers, which is something that states are very conscious of and have tools at their disposal to do.
Let me just talk a little bit about what happened in my state in Ohio. Under the EPA, under Ohio EPA's comments on the proposed Clean Power Plan, it indicated that compliance with Building Block 2, and Building Block 2 is the use low-emitting power sources, using lower-emitting power plants more frequently to meet demand means less carbon pollution is what it says here under Building Block 2. Under the Ohio EPA's testimony, they're looking at the cost to Ohioans approximately $2.5 billion more for electricity rates in 2025 alone. And similarly, the chairperson of the Wisconsin Public Service Commission recently testified that the proposed Clean Power Plan would cost Wisconsin ratepayers between $3.1 billion and $13.4 billion, and this is only production cost increase. It does not include necessary upgrades to the gas and electric transmission infrastructure. That's also going to add up to the cost of compliance. Are these types of costs to implement the Clean Power Plan acceptable from the EPA's perspective?
Well, it's hard to assess costs for a plan that no state has developed yet, and so I can't really speak to them. But I will point out that in the industry we are seeing an increased use of gas and less use of coal because of fuel prices. Gas-based generation is quite economical compared to coal, and so this is the way the industry is going. That's exactly how the Clean Air Act tells us to build our rule, is to look at the direction that the industry is going and set targets based on that.
Well, and you know, like in the state of Ohio, we have a lot of plants that are either going to have to be shutting down or converting, and the number is over 40. But we have to also consider in that number and that cost that they're either going to have to convert those plants or build brand new plants. And so just because the cost of a certain energy out there might be lower today, we still have to have the infrastructure and the plant to be able to produce that power. And so I think those are things that, the EPA has to really look at when you're looking at these numbers. And Mr. Chairman, I see my time has expired, and I yield back.
Gentleman yields back. This time recognize the gentleman from Kentucky, Mr. Yarmouth, for 5 minutes.
Thank you, Mr. Chairman. Administrator, thank you for being here today. You know, I haven't been on the committee for a long time, but already this conversation is sounding a lot like Groundhog Day, which is okay because I know my lines in this play. But, you know, one of the things that astounds me as we talk about environmental issues, and we do week after week in this subcommittee, is that we get a lot of alarmist talk. And this has been the historical pattern for as long as the EPA has been in existence. And I recall the same kind of concerns with acid rain, the same kind of concerns with mercury, the same kind of concerns when we passed Waxman-Markey, at least in the House, in 2009. So just as an analysis that I make, when we were analyzing Waxman-Markey back in 2009, and we had made some significant changes in the way the original bill was introduced that made it easier for states like Kentucky, which gets 92% of its energy from coal, to comply without an adverse impact on our constituents. I started calling our major users of electricity, UPS, we're the global hub of UPS, Ford Motor Company, General Electric, the Louisville Metro government, the University of Louisville, all of those users, and without exception, they were either for the plan or neutral on the plan. So they had made an assessment that there was not going to be any significant impact on their utility costs. As this rule has now been circulating, this proposed rule has been circulating, I've waited for my constituents to chime in, and the same reaction I've gotten. We haven't heard from anybody who's concerned about the long-term implications of this new rule. And I think the reason is that early on, the EPA did allow flexibility, include flexibility among the states. Our governor and our energy department came up with a plan that they thought could help us comply with minimal impact on our consumer rates. And we have to reduce our emissions by 18% between now and 2030 under the rule. That's a little more than 1% a year. So when you actually frame it that way, the idea that we couldn't come up with 1% reduction a year just by conservation, changing insulation patterns, glasses, so forth, is kind of silly. And I suspect, and with all due deference to Texas, I don't know Texas' situation, but it seems to me that that's a small price to pay to have a reduction, a significant reduction in carbon emissions. In my district, carbon emissions not only add to global climate change, but also to respiratory problems. There's a documented correlation between emission of carbon dioxide and those problems. We have a huge problem in the immediate proximity to power plants in my district in Louisville. So all of these things, these doom and gloom scenarios, I don't want to use the pun of the sky is falling, but the doom and gloom scenarios seem to me to not play out in reality. So one question I would ask you is that under the proposed terms of the legislation that we're discussing, do you see any scenario in which opting out of refusing to do your own plan or opting out of a federal plan would result in a safe, low-cost, and clean electricity system going forward?
I think it would be very disruptive to have a system where states could opt out of a federally required plan that other states are doing, and especially with an interconnected interstate power system.
Okay. You know, the chairman asked a little while ago, and chairman's a good friend, why we were doing this, the proposed rule, when there's so many court actions being filed. My state has joined the action, so I'm in all full disclosure. But I think we could probably say the same thing, ask the same question about this bill. Why would we do this when this bill, if passed, would get vetoed? It would never be overridden. But we are getting, again, to make the same arguments that we made week after week after week. So I want to thank you for your work. Again, I think thanking you for providing the states the flexibility to tailor their plans. If we go forward and this is the final action, Kentucky will have a very workable plan to meet the obligations of the Act and with minimal impact on our consumers. So thank you for that, and I yield back.
This time I recognize the gentleman from Kansas, Mr. Pompeo, for 5 minutes.
Thank you, Mr. Chairman, and thank you for being here today, Ms. McCabe. I saw a recent trade report that said there were roughly 650-plus state implementation plans that were backlogged. Is that report correct or roughly correct?
That sounds about right. That refers to a number of different submissions that states would have made, some of them very minor.
Could you provide us a list of all those 650-plus backlog SIPs?
I don't think we have a list of them all because these are handled by our regional offices.
Could you not put them all together? I mean, that'll work for you, right?
Well, I'll take that back.
Doesn't seem hard?
I'll take that back, Congressman.
Wow, can't put together a list from the regions. That's something. Does that not indicate that when these states put together these plans, these are very short timelines for approval of state implementation plans, that there's some risk that the Clean Power Plan might not be able to work? You just don't have the resources to do that and approve these plans in a timely fashion?
No, I expect that the agency would make sure that we
So you'd get to these and you'd put these other 655 in the back of the queue?
Well, Congressman, if I could take a minute and explain
you can take about 10 seconds.
We work with the states to prioritize the plans that they submit to us that make the most difference for public health and welfare in the states, and some are less critical, and so we don't get to them as quickly.
You said a minute ago that you thought that the cost for consumers would be reduced as a result. At the end of 2030, ratepayers would have a lower burden. Is that correct?
That's what our regulatory impact analysis
Why
shows.
on earth are you worried about a state opting out if this is so great? You seem very concerned that a state might opt out. I can't imagine some governor opting out when it's going to save his ratepayers money. I'm interested in why you're concerned about that.
Well, I think we're hearing from a number of states that they don't agree with this program, and so it seems like there might well be states that would.
And why do you think you know more than they do?
Well,
about what it's going to cost the ratepayers. I mean, if this is such genius and such glory and such an enormous cost savings, why aren't you said the Northeast was doing it already, right? Didn't you say the Northeast was already doing efficiency gains?
Yes.
Why do we need this rule? This is beautiful. This is lower cost and lower CO2. This is magic.
Well, this is an urgent environmental, public health, and economic problem that we're faced with.
And you assume the governors care about that too, right? These aren't bad. These governors aren't out to hurt the people in their state, correct?
States are moving in different directions.
No, answer my question. Yes or no? Are governors trying to harm the health of their constituents?
I assume that governors are not trying to harm the
right,
health of
and
their
they'd like to reduce the rates for their constituents too. Is that right? So why? Tell me why this is why your rule is needed if this is such an uninhibited good.
Under the Clean Air Act, we have an obligation to address air pollution that is harming the public health and welfare. Carbon has been identified and confirmed now by the Supreme Court that it is doing that. We are moving forward with.
Right. Let's get to health. You talked about asthma. How many fewer asthma cases as a result of the Clean Power Plan?
We predict that there would be thousands of fewer exacerbated asthma attacks.
How many? Where's the report? Where's the study that shows exactly how many fewer asthma cases?
Those predictions are laid out in our regulatory impact analysis.
How much more increased snowpack as a result of the Clean Power Plan?
That is not something that we predicted, and that's not something that you could predict from a.
These are your indicators. These are EPA's indicators of climate change. They're on your website. I'm staring at it right now.
Yes.
I assume there will be a benefit to the snowpack. So how much more snowpack as a result of the Clean Power Plan?
Climate change is affected by many things. It needs to be looked at over
So you can't,
a long...
yes or no, will there be more snowpack as a result of this rule or less?
That's not something you can
You
predict.
don't, so you don't know? The answer is you don't know.
That's not something that's predictable
How many
by
fewer
a program
heat-related
like this.
deaths as a result of the Clean Power Plan?
I don't know.
You don't know. How much sea level rise will be diminished as a result of the Clean Power Plan?
This is one step, Congressman. It takes many, many steps.
Right. The answer is you don't know, correct? You don't know the answer to the question. You don't know. These are your indicators. This is your science. This is your assertion. It's in deep disagreement with lots of other folks who have a different view of this, and yet you won't put forward the health-related benefits that are associated with this in a scientific way. Instead, you come before us today and make assertions unsupported by data, unsupported by science, and you list a series of indicators and you say, gosh, we're going to put this enormous cost. Your own data says in the billions of dollars, but we don't know what health impact this will really have on America. Mr. McKinley said earlier this is delusional. It's worse than that. It is unfounded in science. And for that reason alone, we need to move forward with this legislation. And Mr. Chairman, I thank you for having this hearing today.
This time I recognize the gentleman from New York, Mr. Engel, for 5 minutes.
Thank you. I'd like to first give Administrator McCabe a chance to answer some of these questions because I don't understand why some governors have an ideological bent and they seem to do things that would pollute the air and not be very beneficial to their constituents. Would you care to elaborate any more because you didn't have very much chance to expand on your thoughts?
Well, people have different views, and states take different approaches to things. What I was trying to say, Congressman, I appreciate you giving me the opportunity, is that Congress, in setting up the Clean Air Act, set up a system where the federal government would set expectations for protecting public health and welfare across the country, recognizing that states make different choices, but also recognizing that a child in Washington State and a child in Florida should have just as clean an environment, regardless of individual choices that their states might make.
Yes, I couldn't agree with you more, and let me remind my colleagues that the Clean Air Act was enacted by an overwhelming bipartisan majority, was signed into law by President Nixon, and it stands as one of the most successful public health laws in our nation's history. Today's discussion draft would indefinitely delay implementation of the Clean Power Plan and allow governors to essentially opt out if they and they alone determine that compliance would adversely impact ratepayers or electric reliability. It's a fact, is it not, that the United States emits more carbon pollution than any other nation except China, and existing power plants of the country's largest single source of carbon pollution? Is that not a fact?
That's correct.
So it's obvious that these emissions have significant health impacts that threaten the lives and well-being of people all over America. But since 1970, we've cut many dangerous air pollutants by 90% or more, while our economy has tripled in size. And I believe that means that millions of lives have been saved and illnesses avoided. And let me quote a peer-reviewed EPA analysis, which estimates that in the year 2010 alone, the Clean Air Act has prevented over 160,000 premature deaths, 130,000 cases of heart disease, 1.7 million asthma attacks, 86,000 hospital admissions, and millions of respiratory illnesses. And the monetary value of saving Americans from those harms is projected to reach $2 trillion in the year 2020 alone. And from 1990 through 2020, the monetary value to Americans is projected to exceed the cost by a factor of more than 30 to 1. I'm particularly interested in it, Madam Administrator, because my district has some of the highest rates of asthma in the United States. Rates of death from asthma in the Bronx, where I'm from, are about 3 times higher than the national average. Hospitalization rates are about 5 times higher. And it seems to me that today's discussion draft would endanger lives and jeopardize health by dramatically weakening and delaying the Clean Air Act safeguards. So let me ask you, Madam Administrator, will you please talk about how air pollution impacts the health of our communities and explain how this discussion draft would delay or prevent the air quality benefits of the Clean Power Plan?
Well, it's very clear that air pollution does affect the health of people in our communities, and especially people who low income and communities of color that already are suffering from a variety of pressures on their health and on their health care. Higher levels of particulates and nitrogen oxides and sulfur dioxide lead to asthma, as well as heart attacks, other sorts of respiratory illnesses, and in some cases premature death. And all of that information is very well established and very well laid out. So the Clean Air Act has been incredibly helpful to the public health of this country, saving much suffering, much cost to those families' lives and to the economy from the health care costs avoided.
Can you elaborate on the state flexibility, because there is flexibility, of the Clean Power Plan in terms of state implementation?
Yes, there is a long trajectory in time for states to design plans that work for them. There is no prescribed approach for any state to follow, so they can be very respectful of their particular power sources and the needs of their communities. There is the ability for states to cooperate with other states, either near or far, in small or large groups to widen the pool of cost-effective approaches. So this system, which Congress set up to allow states to do these sorts of plans, is very well designed to afford lots of flexibility.
Well, thank you, and thank you very much. I'm very pleased that you're raising these issues today, because the health of our constituents depend on it. Thank you so much.
This time, recognize the gentleman from Illinois, Mr. Kinzinger, for 5 minutes.
Thank you, Mr. Chairman, and Administrator, thank you for being here with us. Appreciate your service and being willing to come in front of the committee. In the proposed rule, your agency sets out state-specific goals for reducing carbon dioxide in the power generation section. More specifically, the rule says that once final goals have been promulgated, a state will no longer have an opportunity to request that the EPA adjust its CO2 goal. I just want to delve into that a little bit, just so that I know. In the final rule, will the carbon dioxide goals set for each state be fixed? Will they be fixed in number?
That is what we proposed, and so we're looking at the comments that we received on that, Congressman. But that's so we're looking at that. But
okay.
the idea is that states should be able, once the rule is final, to go forward and develop and implement their plans.
So let me delve into that a little further. You know, I've seen a number of studies come out recently concerning the price. We've talked about that a lot, the price increase with these rules potentially. Will there be an opportunity for a state to request that the EPA adjust those goals if the state administrators find that those goals will cause electricity prices to substantially increase?
That is not what we proposed. We believe that the plan allows enough flexibility that states should be able to implement these plans in a way that is reasonable and will protect affordability.
What kind of flexibility? I mean, if you have a number that's set and then the state basically comes back and says, hey, look, we've got information that says this is going to skyrocket prices on our customers. Mm-hmm. What's the flexibility that we can adjust that besides actually adjusting that if that number stays fixed?
Well, I would say that if a state found some sort of extraordinary problem with a plan that it had developed, there's always the ability to come back and talk to EPA about making adjustments. But it's important
well,
that—
you just said it's fixed, though. It's a fixed number.
But it's important that the goals be clear, and it's important that the goals be fairly set across the country from—
Well, yeah, and I get the clear thing, and if this works out, I would imagine a state would want to stick with it if, as you say, this drives down prices and it's amazing. But if they find out that this isn't, you know, quite what it's sold to be, I mean, I would think that there would be an opportunity to adjust that beyond extraordinary measures, something that would be— it doesn't even have to be extraordinary, just taking measures to adjust something that doesn't seem to be working out.
I think we need to remember that these plans will be implemented in the context of the changes that are happening in the energy system now.
So the same is for the assigned goals in terms of reliability. Should there be an opportunity, if reliability, not just pricing, you know, pricing we can get, but reliability is a real national security issue. Mm-hmm. Would there be an opportunity for a state to make an adjustment if that situation came up?
Right. So as I've said already this morning, we are looking and talking with organizations like FERC and others who are expert in these issues to make sure that our final rule will protect reliability.
Well, I would hope so, and I just want to add to that. You know, look, pricing increases to me is very important, and it's very detrimental. But I think even above that is, power reliability issues, and there ought to be a real off-ramp. And I would also add, and I think I'd probably get the same result from you, but when it comes to like issues of job loss, if it's proven that this could create job loss, there ought to be an opportunity for states to make adjustments. Would there be any other federal agency or state agency that would have a role in deciding whether to change the goal at this point? If you were setting out goals for states, any agency besides yours that would have any input in that?
Well, it's really EPA's responsibility under the Clean Air Act to make those decisions.
Okay. And I just I already talked about the issue of an off ramp if you have reliability, and again I want to put in a good word for that because I think that would be extremely important, and you've probably seen that in a lot of your comments. So with all the regulations coming down from EPA and then the discussion of this, are we locking states into economic hardship in regards to these mandates coming down from the federal government and as a result of these newly proposed rules?
I would say that we're not, Congressman. I know there's a lot of debate about those issues, but I would encourage people to think about the flexibility that's here, the opportunities that people are seeing. There's a lot of positive conversation going on around the country about
I agree, and I would love to see positive conversation and flexibility when it comes to your role in this, because I think, listening to the states on the ground that have a real interest in this, that, live this day by day. I fly airplanes. I'm not a manufacturer, so I listen to a lot of manufacturers about what works for that to become an expert. So I'd hope you would listen to states in this process and understand what situations may come up. With that, I'll yield back.
Gentleman yields back. At this time, recognize the gentlelady from Florida, Ms. Castor, for 5 minutes.
Thank you very much, Mr. Chairman, and welcome, Administrator McCabe. As under current laws, EPA begins down the road of the Clean Power Plan. EPA will set the overall carbon emission reduction goals under Section 111D of the Clean Air Act, and then it's up to states to determine how best to achieve the reductions. And as states begin to set the goals and establish plans for carbon reduction, it's clear that consumers' pocketbooks will be better off when states plan ahead and when they use many different and varied tools to reduce carbon pollution. You mentioned a few here today. Conservation plans for states. Are they going to be, consumers going to be better off if a state has a robust conservation plan?
Yes,
Do you agree?
they will.
And energy efficiency?
Yes, absolutely.
So what do you say to states that are moving backwards on that today?
Well, it seems that there are opportunities out there that we would think every state would want to take advantage of, and some states are further ahead than others, and that's what the Clean Power Plan anticipates, is that those kinds of measures will indeed be implemented.
Wouldn't that raise a red flag for consumers if they know, okay, we've got to reduce carbon pollution, but then leadership at the state level says, well, our idea of doing that is to eliminate conservation goals? Shouldn't that raise a red flag for consumers in their pocketbooks?
Well, a lot of Americans across the country are very smart about these issues, and we're hearing that they are in favor of moving forward with this kind of plan for both the economic and the public health benefits that it'll provide.
Now, what's the starting line on this? For states, what do you tell them is the baseline? Because you've got to establish a place in time where all states have to start and then measure their plans and their goals for reduction.
Right. So we started with 2012. This is a rule that requires us, as I mentioned this morning, to look around and see the effective measures that are being used and have an expectation that those will be increasingly used all across the country. So that's what we did, but we looked at states where they were in 2012 and projected forward.
So if they've reduced their carbon emissions from 2012, they will get some credit towards their state goal.
Well, their carbon emissions are down. If they have already taken steps to implement energy efficiency, to invest in renewables, their carbon emissions are already going down, so they're that much closer to their goal.
Is there any way for a state to get credit for reductions prior to that date of 2012?
Well, this is a good issue, and a lot of people have raised it to us and given us different ideas about it. The key issue is any reduction made early is a reduction that doesn't need to be made later. So that's a very good thing for people to do, and as you've noted, planning, having a robust planning process is going to make it most cost-effective, affordable, and reliable as the states implement their plans.
Now, one of the problems I see especially in my home state of Florida, where the costs of the changing climate are so severe in the out years, is the problem is the state utility framework and the costs that they can consider. Because typically in the Public Service Commission framework and utility regulations, they don't consider costs of flood insurance because of sea level rise. They don't consider cost of property insurance increases on consumers. They don't have to take into account increases to property taxes when a local government has to address flooding from stormwater. Can EPA provide any guidance to states on this? Or you say you have all the flexibility in the world, states, and you need to consider those costs broadly?
Well, we do give the Clean Air Act gives the states the flexibility to do that. I'll note that we predict in our regulatory impact analysis a significant net economic benefits from this rule on the order of $30 to $49 billion, and that's taking into account the expected benefits to constituents like yours in Florida that are seeing the impacts of climate change today.
I'm sorry that I've run out of time. Thank you.
This time, I recognize the gentleman from Virginia, Mr. Griffin, for 5 minutes.
Thank you very much, Mr. Chairman. In response to your answers to several people, including Representatives McKinley and Pompeo, I would just have to point out that the Virginia State Corporation Commission does not agree with you that this is going to somehow make the price of electricity go down, and I quote, "To achieve the carbon emission reductions required by the proposed regulations, customers in Virginia will likely pay significantly more for their electricity. The incremental cost of compliance for one utility alone, Dominion Virginia Power, which only serves 2 of the 29 jurisdictions I represent, would likely be between $5.5 and $6 billion on a net present value basis. In addition to new investment, Virginia residents and businesses will also be responsible for paying remaining costs for useful existing facilities forced to retire prematurely under the proposed regulation. The proposed regulation places at risk several billions of dollars of recent investments in existing coal-fired facilities. Contrary to the claim that rates will go up but bills will go down, experience and costs in Virginia make it extremely unlikely that either electric rates or bills in Virginia will go down as a result of the proposed regulation." Now, I assume that you're aware that the Virginia State Corporation Commission is not some private body of electric generators. That is the regulatory agency that sets the electric rates in Virginia, that says what the companies can charge, and they say, just to one company, it's going to cost $5 to $6 billion. When you add in all the other companies, it's going to be billions, and that it is highly unlikely that the rates will go up, but the bills will go down. They said extremely unlikely. Let me get it correct. I said highly. They said extremely unlikely that either electric rates or bills in Virginia will go down as a result of the proposed regulation. So I just point that out to you, so when others say, please listen to these folks, they have decades of experience in figuring out what the rate is supposed to be so that the electric companies don't charge too much, but get a return for their heavy investment. Now, that being said, you also indicated that folks were moving to gas-based generation as it's more affordable. That is true today, although even last year for a number of months, the rate was over. The cost of natural gas was higher than that which would cost to create the same number of BTUs with coal. That fluctuates, but further, you have to build pipelines. Now, right now in my district, there's a big pipeline being proposed to be built, and in the non-coal producing areas of my district, people are opposed to that pipeline because they're not sure that at that size it's going to be safe. So I submit to you that we may not be ready in 2020. And further, I would ask, don't y'all work with the DOE? Because they're working on clean coal technologies, and they have indicated to us that it will be probably about 2025 before those new technologies are on board. But according to your plan, at least as we've heard about it up to this point, you keep pointing out it's not final yet, the states are supposed to come up with their plan 13 months after the final rule. So this is 2015. Sometime in 2016, Virginia's going to have to come up with a plan. They can't wait until 2025 when the new technologies will be viable, and there's 5 or 6 clean coal technologies that look really promising. How much greater benefit are we going to get as a society in that 5 or 6 or 7 year period that we're going to put lots of people out of business, raise the cost of electricity, and yet the technologies are almost there? I would submit the plan is flawed, and that's why we need this bill. I would also say to you that, and I would have to ask this from a legal standpoint, if one state were able to pull out of your plan under a legal theory, would that destroy your plan? Yes or no?
It would be inconsistent with the way the Clean Air Act works, and it would be disruptive.
But you understand that Lawrence Tribe, when he was here to testify, I asked him about collateral estoppel on the case that I asked you about last time, where the EPA lawyers conceded that you didn't have the power under 111D to do this regulation. He said collateral estoppel would only work, or res judicata would only work for the state of New Jersey if they chose to use it. You could lose on that point. Now, I don't think you're right on 111D anyway. I don't think you have that authority. It's interesting, though, that this bill would say that all of these cases would have to go forward, but this Thursday you're arguing in front of the Circuit Court of Appeals that it's premature to bring the court case that says you don't have the underlying authority. Wouldn't it be great to go ahead and get the Supreme Court to decide whether any of this regulation, final or otherwise, whether you have the authority to regulate at all under 111D, the existing power facilities, electric generation units? Wouldn't that be great to go ahead and get that out of the way? And why would you all want to stall that? And wouldn't this bill, if passed, encourage you all for judicial efficiency to go ahead and let's find out whether or not you have the power to do what you say you do? I don't think you do. You think you do. The Supreme Court has yet to rule. The more you delay makes this bill more practical. Your arguments on Thursday make me want to carry this bill. Thank you very much, and I yield back.
This time, recognize the gentleman from California, Mr. McNerney, for 5 minutes.
Well, thank you, Mr. Chairman. Ms. McCabe, in light of the fact that human-caused climate change is advancing and that the impacts are going to be more and more severe over time, I've suggested to my colleagues that have coal-fired interests that they embrace carbon sequestration, carbon capture and sequestration, sort of to protect their local industries. How would the implementation of CCS impact coal-fired power plants under the Clean Air Plan?
CCS would be a technology that a state could choose to build into its plan as a way of reducing carbon emissions from their coal fleet.
So in a sense, it would protect their coal-fired power plants and the coal miners and on down the line.
That's correct.
Thank you. Have you studied the discussion draft?
Yes, I have.
Do you think that carbon emissions would be reduced under the Clean Air Plan if this bill is adopted?
I don't think it would be. I think it would all be delayed.
Delayed? More than delayed? Do you think it would be completely disrupted?
Perhaps, yes.
Have the states worked well with the EPA to develop the clean power, under the Clean Air Act? Have they worked together well under the Clean Air Act?
Absolutely. There's been tremendous discussion from states all across the country, and we continue to have those discussions.
Well, my region is the Central Valley of California, the northern part of that Central Valley. If this bill is adopted, how do you think that would affect the air quality in that region?
Well, it would mean that states would delay, in the first instance, putting their plans together. Not just California, but all states would. And states having the option to opt out of the plan altogether could certainly impact California.
Thank you. FERC recently had a listening session on the Clean Power Plan. What was your takeaway from those hearings?
Those were very interesting conversations. We very much appreciated being a part of them. I think we heard a lot of the things that we've been hearing from people in their public comments to us, which makes sense. A lot of good questions, a lot of good discussion, interest by FERC in making sure that they understand how they can be helpful to EPA as we go forward and do our job under the Clean Air Act. So I think it's served as another opportunity for people to raise their concerns and also as a basis for ongoing conversation.
So in your opinion, it was a positive conversation?
Absolutely.
Are you having those kinds of conversations in states about the Clean Power Plan?
Oh, certainly, yes.
And a lot of those are productive?
They are. They are.
Are there many that aren't productive?
Well, I think when states come and sit down with us, they have questions about how to go forward with this, and we're working with them on the kinds of resources that they'll need, technical resources, training that they'll need. There's great interest, and I recognize that there's controversy as well, but when we sit down with the environmental regulators, they're focusing in on how to make this work.
Do they share the kind of concern about economic impact that we're finding here today?
I think everybody wants to make sure that we can implement this program just as we've implemented so many under the Clean Air Act in a way that preserves affordable and reliable electricity from this country, but also delivers the billions of dollars of benefits to the public health and welfare and to the economy of this country that over the years the Clean Air Act has delivered for the American people.
So would you say that the effort to reduce sulfur dioxide emissions had a positive impact on the economy?
Absolutely, I would, yes.
And your opinion that this Clean Air Plan could be similar in its results?
Oh, and it's absolutely essential given the threat to our country that climate change poses.
All right, well, thank you. I yield back.
Thank you.
This time I recognize the gentleman from Ohio, Mr. Johnson, 5 minutes.
Thank you, Mr. Chairman, and Ms. McCabe, thank you for being here with us today. I'm in favor of both gas-fired and coal-fired power to heat and cool our homes and run our businesses. I think we need both, and I think that's very clear. I see in a dichotomy, though, a conflict between Building Block 2 and Building Block 1 of the proposal. In Building Block 2, the EPA assumes that gas plants will run far more at a 70% capacity factor in order to run coal-fired plants far less. This will reduce the heat rate efficiency of coal-fired plants because running any plant less and on an intermittent basis always reduces efficiency. Anybody that understands the science and technology of coal-fired power understands that. So what this says to me is that Building Block 2, which calls for running coal plants less, is at odds with the goals of Building Block 1, which calls for improving the heat rate of coal-fired plants. You can't run coal-fired plants less while running gas plants more and then turn around and argue that the heat rate of coal plants should be improved. To me, this seems an obvious example of using big government implementing rules that are practically impossible for an industry to meet, in this case, the coal-fired industry. So my question to you is, did the EPA consider that the amount of switching to natural gas effectively required by this rule would require coal power plants to operate less, thus driving up heat rate substantially while eliminating the heat rate improvement at the coal units? Help me understand this conflict.
Well, so one thing, it's important to note that the building blocks we used are not a prescriptive formula for every state or for any state. It was a way of characterizing the kinds of approaches that are used that reduce carbon. And we do predict that there will continue to be baseload coal-fired power plants providing power.
Okay, so I can get to my other questions.
Yes, sir.
Let me stay focused here. Would you agree, I understand that, so it was not a prescriptive formula.
Yeah.
But would you agree that requiring coal plants to run less in one section and then mandating that it improve its heat rate efficiency in another section, that is a dichotomy? Those two things are in conflict?
Well, I understand that when.
Yeah, I mean, I mean, you understand the technology. That's a yes or no question.
I do understand the technology, and it can be harder to run as efficiently when you're running less.
Okay,
but
I'll take that as the answer. I personally feel that this demonstrates an extreme shortcoming of the proposal, Ms. McCabe, because what may be called flexibility is really the closure of a significant percentage of the plants that power America. Even before 111D takes effect, we will have huge numbers of retirements of coal-fired plants because of that intermittent on and off again running less situation. It's also clear, turning back to some of the questions or the areas that some of my colleagues have addressed, that at the same time states would be developing the plans, there will be serious legal questions about the Clean Power Plan regulatory scheme. And I heard one of my colleagues ask the question earlier. The EPA, by its own track record, is unlikely to be providing timely guidance and assistance to the states, and the agency appears not to want to consider slowing down the process time. Whatever the confident assurances of the agency are, this is going to be a very messy process, and I think that everyone understands that. So why would you not want to resolve the legal issues before you and your agency go through the work and you put the states and the industry to all this problem? Why would you not support wanting to let the legal issues work themselves out? What is the rush to judgment on this that's in our interest before we answer the legal questions about whether or not you guys should be able to do this or not?
Well, first, Congressman, there's no way that the administrator would sign a rule that she did not believe was fully within her authority. So
can you tell me that you think that there are not going to be legal challenges to this? I mean, and have you guys not listened to, or have you not heard the many voices that are decrying the EPA's authority to do this?
We have heard many of those.
Why wouldn't you want the courts to make that determination before? I mean, you've seen your budget drop 20% over the last 5 years. Your staffing levels continue to come down, and you complain that you don't have enough money to do what you're supposed to do, or enough people to do what you're supposed to do. Why would you want to take on something that you might have to turn around and throw away if the courts decide you didn't have the authority to do this?
Because
I'm out of time, Ms. McCabe. I'm sorry. I wish I could give you time to answer that question. But that just seems like a flawed approach and not in the best interest of hardworking Americans to spend their money this frivolously on something that we know the courts have major questions about. Mr. Chairman, I yield back.
As the gentleman's time has expired, at this time I recognize the gentlelady from North Carolina, Ms. Elmers, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Ms. McCabe, for being with us today. I've listened to so much of the testimony and the questions, and I think this is a very well-rounded discussion that we're having. And again, you know, for me and my constituents back in North Carolina, this is obviously going to negatively impact the consumers and their utility bills. It's going to increase the cost, and I understand the issues. You know, certainly we all want clean air, and we want to do everything we can to achieve that. But I do have some specific questions. When we're talking about the litigation moving forward, and you know, you had mentioned in the budget proposal that the EPA expects a great deal of litigation, and this kind of comes again after Mr. Johnson's testimony. You know, one, what type of litigation are you anticipating, and how long do you expect the judicial review of the initial legal challenges to take?
So we do expect legal challenges. EPA gets challenged on many of its rules, as you know, and it can take several years. And if it goes all the way to the Supreme Court, that can add time to it. And then even after that, it could go back, if it goes to the Supreme Court, it could go back to a lower court for further proceedings.
Given that fact, and obviously we're looking at an incredible amount of time, years, in fact, we're still looking at this situation, and we are hearing from our states. I certainly am hearing from North Carolina how this is going to be very, very difficult as they are trying to go through the rule and address the issues. There is a 1-year extension that's proposed in the rule, but that obviously is not adequate in the timeline that we're talking about. So given the fact that we know that this could, litigation could move forward for years, how does the EPA plan on dealing with this issue? Will they demand that the states be required to submit their state plans, or are they going to hold back on that issue, allowing the states to see what the courts are going to do?
Well, Congresswoman, the judicial system already has a way of dealing with this. So, as I've said, EPA gets challenged on many rules. In this administration, most of our rules have been found to be lawful, and work has gone ahead on them. If a court finds that our legal basis is so questionable that they think that we are not likely to succeed on the merits, they can, in response to a request, put a judicial stay in place that would then toll the requirements, and that has happened on occasion. We don't believe that a court will find a substantial likelihood that we will not succeed.
And there again, to that point, and thank you, that would certainly help the situation, but it also doesn't alleviate the cost that our states are incurring. This will be an incredible cost to North Carolina, as it will all of my colleagues in the states that they represent. According to the Unfunded Mandate Reform Act, the EPA is required to estimate the burden on states to develop state plans. So considering this and considering the length of time we're looking at, what does the EPA estimate will be the cost to states to prepare state plans?
I believe we estimated that. I don't have those numbers with me, Congresswoman, but we can get them.
Okay, if you could provide that to the committee and also to my office, I would appreciate that. Thank you. And in light of the comments that have been made regarding the proposed Clean Power Act, is the EPA going to reevaluate these estimates? So moving forward, as the comments are being made, is there a process to reformulate the plan, or are we sticking to the plan until the process moves through? Will you adjust and be flexible to the comments that you're receiving?
Oh, absolutely, and you'll see that in the final rule that we will have been responsive to many of those comments.
In my last 40 seconds that I have, I do want to go back to a question that my colleague from Illinois asked, Mr. Kinzinger. He was asking, the EPA is the only agency, and then you had also commented to one of my other colleagues that you were working with FERC and that there was hearings with FERC. If FERC comes forward and tells you, in fact, again, going off of Mr. Kinzinger, that there is a reliability issue, that there is a national security issue with us, will the EPA take that recommendation and use that moving forward?
Well,
are you required to do so?
We're so far away from states developing plans that anybody could make a sound judgment on reliability about. So we will do our job under the Clean Air Act. We will take into consideration any input that we get from anybody, and we certainly will listen very seriously to any input that FERC wants to give us. But we're just not at a point where anybody could make that pronouncement at this point.
Thank you, Mr. Chairman. I went over my time a little bit.
This time, recognize the gentleman from Oklahoma, Mr. Mullen, for 5 minutes.
Thank you, Mr. Chairman. Ma'am, I really almost feel for you because the way that you're sitting here having to take these questions, I can tell you're just having a blast doing it. And I'm meaning that a little cynical there, but you are here, and I really do appreciate that. However, I do question the direction that the EPA is going with this. I've heard you talk about that many Americans believe with you, and they're with you on this, but yet all the reports we keep hearing back over and over again isn't true. I mean, the only many Americans I can assume you're talking about is Sierra Club and some environmentalists that live in the city and they don't ever live in the country, which I find quite hilarious sometimes, because if you're an environmentalist, you would think you'd want to live in the environment. But besides that, you go into the fact that you're saying that you're not going to reduce the amount of energy being generated. Is that right? You don't find there a concern with the amount of energy being generated?
Well, we think there are many opportunities to employ energy
What are
efficiency,
those opportunities? Because just in Oklahoma alone, just in my district, we're going to lose 3,000 gigawatts, which is about 70% of our coal-fired power plants. Southwest Power, who represents that region there, they're saying they're going to lose 13,900 megawatts. What's going to replace that?
Well, I'm not sure exactly what the SPP is basing all of those predictions on.
Ma'am, these are the figures that are coming from the individuals that's providing my constituents and providing my region with power.
Right.
Now, if the EPA is doing their diligence by understanding the research that they're putting out there, and before you come in front of Congress and you start relaying these facts that you don't believe it's going to reduce power, wouldn't you think about talking to the stakeholders? I mean, these are the individuals that's responsible for providing reliability to us, that when we flip our switch on, it's going to work.
We certainly are talking with all of these entities, including
so what's going to
organizations
replace
like
this?
that. It will be different kinds of generation. I can't.
What kind of generation are you going to replace it with? Because not all regions are the same. We don't have the same flexibility as everybody else. The infrastructure isn't in place yet. The EPA is moving on with this rule. I mean, you're talking about saying that it's not going to reduce reliability, but ma'am, the fact is it will reduce it. If we're taking that much off online, wouldn't the EPA have some type of study out there to back up what you're saying, that it's not going to shut down or reduce reliability? Wouldn't you think there would be something out there that you would back up what you're bringing facts? I'm assuming the rest of America is going to believe you're backing your statements up with facts, aren't you?
Absolutely. And
so what are those facts?
We have analysis. The Department of Energy has done various kinds of analysis.
What is it that you're talking about specifically? What's going to replace it?
Well, as you have said, every state is different. Their needs and their flexibilities are different.
But you're treating all states the same.
No, we're not treating all states
really?
the same. No.
Well, you're making them all comply.
We're asking them, we're setting targets for them that are based on a uniform approach across the country.
Which is a one-size-fits-all approach, which is Washington, D.C. You said a uniform approach.
No, it is not one-size-fits-all.
Well, a uniform is everybody looks the same. That's the purpose of a uniform.
Okay, well then I'll change my word. This is not one-size-fits-all. This is an approach that takes into account the energy needs and the energy resources of every single state.
Okay, man, we're going to agree to disagree on that one, because the fact is you're talking in circles. Now, let's go back to the thing that you said, that it's not going to cost the individual, the inline, the ratepayer, it's not going to raise their cost. Isn't that what you said?
That's what our national analysis shows.
Where are you getting that statement? Because Southwest Power said it's going to cost them $2.9 billion per year to comply. $2.9 billion per year. Now, if you understand business at all, you'll understand that that has to be passed through to somebody. So if it's going to cost just Southwest Power $2.9 billion per year, who's going to pay for that?
There are investments that everybody is making that they look at over time. Remember, we have a long period of time to implement this.
Who's going to pay the $2.9 billion a year? It's not just investments. It's got to be passed on to somebody. Is the EPA going to pay that out of your budget?
What our analysis shows and what other people look at is...
Analysis, ma'am, we've already proved that your analysis isn't lining up. It's an assumption. You keep calling it an analysis. It's an assumption that you're calling an analysis. The truth is, the $2.9 billion, the cost has to be passed on to somebody. And ultimately, it's going to be all of our constituents that's going to be paying for it. And it looks like to me that the EPA's analogy is, well, we know best, just shut up and follow us. You wasn't elected, we were, and we're elected to represent our constituents. Thank you.
Gentleman's time's expired. Is Mr. Flores around? Does anybody know? No? Okay. Well, I guess that concludes the questions for Ms. McCabe.
Mr. Chairman?
Yes.
Mr. Chairman, I know, and I just heard a number of members had questions about the EPA's analysis, and some have suggested that the EPA didn't even have enough analysis. And I just wanted to inform the chair and the other members that here I'm in my possession, I have about, I guess this is 10 to 12 pounds of analysis from the EPA, the regulatory impact analysis for the proposed carbon pollution guidelines for existing power plants and emission standards for modified and reconstructed power plants. Now, I really, Mr. Chairman, I'd be happy to move that this be included in the record. I just don't want it to be said again and again and again that the EPA do not have an analysis, here it is. This is the document, about 10 pounds of it, and so I don't know. I'd be happy if the chairman informs me or desires. I'd be happy to ask moving that this get included into the record, so that we can just put to rest the fact that the EPA does not have an analysis. And so,
well, let me just say, we understand the EPA has a lot of analysis, and we have a lot of industries, utility companies, local communities that have analysis as well, and they don't agree. So that's where we are.
Mr. Chairman, I just want to say that it's been said so many times, it's almost it's hurtful and harmful to keep hearing that the EPA doesn't have an analysis. And here it is, 10 to 12 pounds.
So are you moving that we put it in the record? Or
I don't know, Mr. Chairman.
Okay.
It'll take up too much paper and too much.
Yeah. But thank you so much for bringing it to our attention.
I want you to know that there's an analysis.
We appreciate that.
Here it is right here.
Ms. McCabe, thank you for being with us today. We're going to continue to engage you and EPA on this issue as we move forward. This time I'd like to call up the second panel. And on the second panel, we appreciate your patience this morning. We have Mr. Eugene Trisco. I tell you what I'm going to do. I want all of you to just come on up, and I'm going to introduce you right before you give your 5-minute opening statement. So if you all would have a seat, and then we'll begin on the left with Mr. Trisco, and then we'll let each one of you give your 5-minute opening statement. So our first witness this morning is Mr. Eugene Trisco, who's the energy economist and attorney on behalf of the American Coalition for Clean Coal Electricity. And once again, thank all of you for being here. Thanks for your patience. We do value your comments and thoughts on this important issue. So, Mr. Trisco, I'm going to recognize you for 5 minutes. And you'll note that there is a little box on the table, 2 of them. They have colors, and when it gets red, that means the 5 minutes is up. So just be aware of that. And also be sure and turn the microphone on so that all of us can hear. And Mr. Trisco, you're recognized for 5 minutes. Excuse me, Mr. Trisco. Would you just move the microphone a little bit closer because some of our members were having a little bit of an issue? Thank you. Is your microphone on?
Will this help? Should I go back to the top? We started at good morning. Mr. Chairman, we've analyzed consumer energy costs for 31 geographically diverse states, and these states are expected to be states that will be heavily impacted by EPA's Clean Power Plan. The 31 state reports analyze the pattern of energy expenditures among 3 categories of pre-tax and after-tax household income. The studies rely on actual state residential energy expenditures in 2014 from the U.S. Department of Energy's EIA and government surveys of residential and transportation energy consumption for household income groups. The household income data are based upon U.S. Bureau of the Census data for 2013, the most recent data available. Energy expenditures as a percentage of after-tax income are estimated for the effects of federal and state income taxes and federal social insurance payments using CBO tax rates and individual state income tax data. The key findings of these studies are, first, 1/2 of the households in these 31 states have average pre-tax annual incomes below $50,000. The median after-tax income of these 38 million households is $23,317, equivalent to a take-home income of less than $2,000 per month. The 50% of households in these 31 states with pre-tax incomes of $50,000 or less spend 14 to 19% of their after-tax income on residential and transportation energy, with median expenditures of 17%. Low-income families, those with pre-tax annual incomes less than $30,000, represent 30% of the households in these 31 states. Their median after-tax income is $15,464. These households spend an estimated 18% to 25% of their after-tax income on residential and transportation energy, with a median expenditure of 22%. Recent consumer savings at the gas pump are being eroded by steady increases in electricity prices. Residential electricity represents 76% of total residential energy expenditures in the 31 states on a household weighted average basis. From 2005 to 2014, residential electricity prices in the 31 states increased overall by a weighted average of 38% in current dollars and by 13% in constant 2014 dollars. Large electric price increases will result with the implementation of EPA's proposed Clean Power Plan. A recent analysis by National Economic Research Associates estimates that the carbon rule will increase delivered electricity prices in the 31 states by 15% on average during the period 2017 to 2031. These average price increases mean that electricity prices for consumers will be 15% higher on average each year under the Clean Power Plan than they would be without the Clean Power Plan. Peak year electric price increases during this period averaged 22% for the 31 states. These estimates are conservative because NERA did not consider any additional natural gas infrastructure or electric transmission investments needed to comply with EPA's proposed rule. The U.S. Census Bureau reports that the real pre-tax incomes of American households have declined across all 5 income quintiles since 2001, measured in constant 2013 dollars. The largest percentage losses of income are in the 2 lowest income quintiles. The loss of annual income among all American households averages $3,947 per household since 2001. In comparison, DOE's current estimate of annual gasoline savings for American consumers due to lower oil prices is $700 per household. Declining real incomes increase the vulnerability of lower income households to energy price increases such as rising utility bills. Lower income families are more vulnerable to energy costs than higher income families because energy represents a larger portion of their household budgets. Energy costs reduce the amount of income that can be spent on food, housing, health care, and other basic necessities. The data presented in the 31-state report show that minorities and senior citizens are disproportionately represented among these lower income households. Thank you for the opportunity.
Ms. Triscoe, thank you. And our next witness is Ms. Lisa Johnson, who is the CEO and General Manager of the Seminole Electric Cooperative on behalf of the National Rural Electric Cooperative Association. And your all's headquarters is in where?
Tampa, Florida.
In Tampa, okay. You're recognized for 5 minutes, and just be sure the microphone is on.
Thank you, Mr. Chairman, Ranking Member Rush, and members of the committee. I appreciate the invitation to address the challenges facing electric cooperatives as we work to comply with EPA regulations. My name is Lisa Johnson. I am the CEO of Seminole Electric Cooperative, and I am also testifying on behalf of the National Rural Electric Cooperative Association. I applaud this committee's willingness to examine complex issues, such as 111D regulations, and work toward an equitable solution. While everyone can agree on the importance of environmental stewardship, regulations that would eliminate whole industries, drastically raise electric rates, and call into question the reliability of our nation's transmission grid are excessive and unnecessary. I am here today to express support for Chairman Whitfield's discussion draft, the Ratepayer Protection Act. This act would delay the Clean Power Plan to ensure that it survives legal challenge before taking effect and provide states like Florida with an important safety valve for consumers and for the reliability of the grid. Seminole Electric Cooperative, through our 9-member, not-for-profit, consumer-owned electric cooperatives, serves more than 1.4 million individuals and businesses in 42 of Florida's 67 counties. The residential customers our members serve are predominantly rural. Approximately 1/3 have household incomes below the poverty level, and more than 75% have household incomes less than $75,000. Seminole employs more than 500 individuals at 3 locations in Florida. Our headquarters in Tampa, the Seminole Generating Station, or SGS, a 1,300-megawatt coal-fired power plant located in Northeast Florida, and the Medulla Generating Station, or MGS, an 810-megawatt natural gas-fired power plant located in South Central Florida. SGS employs more than 300 individuals and provides more than 50% of the energy used by our members. Under the proposed Clean Power Plan, SGS would close by 2020. Despite being one of the cleanest coal plants in the country, despite Seminole's environmental investments of more than $530 million, and despite having a professionally rated useful life that carries into 2045. Worse, the financing structure for SGS carries through 2042. If the plant closes in 2020, our members will continue to pay for it, in addition for paying for replacement generation. SGS is the bedrock of rural Putnam County. In addition to our hardworking employees, there are often hundreds of contractors on site. On March 11th, there were 732 contractors at SGS addressing work during our spring maintenance outage. These contractors stay in local hotels, eat at local restaurants, and shop at local retailers. Seminole is also the largest taxpayer in Putnam County, paying more than $5 million in property taxes in both 2013 and 2014. Rural Putnam County and the city of Palatka cannot afford to lose SGS or any of the associated jobs, especially by 2020. Closing SGS prematurely would call into question our ability to generate and transmit electricity to our members. In 2014, more than 50% of our members' energy requirements were served via SGS. Seminole does not have sufficient natural gas facilities to serve this load adequately without our coal units. And Seminole will not be the only utility in need of new sources of electricity. EPA's own model calls for the closure of more than 90% of Florida's coal-fired units. Florida's existing transmission constraints, both in and out of state, and EPA's short compliance timeline will prevent us from purchasing or building this power economically if it is feasible at all. The only viable option to replace SGS is natural gas. Florida is already 65% dependent on natural gas for generation, and the likely effect of the Clean Power Plan is that this percentage will soar to 85%. This over-reliance on one fuel source exposes us to the price fluctuations and volatility common in the gas markets. The new gas-fired generating facilities, transmission infrastructure, and pipelines needed to replace the output of just SGS cannot be permitted and completed by 2020, even if we started today. If the Clean Power Plan takes effect before the construction of sufficient generation or transmission infrastructure, significant power deficiencies may occur, harming reliability. The Clean Power Plan has failed to recognize the economic impacts it would have on Seminole, our employees, our member cooperatives, and the communities that we support. It has also failed to present a proposal that would maintain reliable electric service for our members and for Florida in general. As such, Seminole supports the Ratepayer Protection Act and urges this committee to continue its work to protect consumers. The best result for Seminole is for EPA to withdraw its proposal. In the absence of that, this legislation will protect Florida and Seminole by ensuring we do not have to comply with regulations that may be unlawful or may seriously harm consumers. A lot of us take it for granted that when we flip a switch, the lights come on. The Clean Power Plan, as proposed, will call that into question. Thank you.
Thank you, Ms. Johnson. At this time, I'd like to recognize Susan Tierney, who is the Senior Advisor with the Analysis Group, and thanks for being with us, and you're recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman, Ranking Member Rush, and members of the subcommittee. My name is Susan Tierney. I practice economics in the electric and natural gas industries. I'm a former state utility regulator, a former state environmental official, and formerly the Assistant Secretary for Policy at the United States. 1 out of every 15 tons of carbon emission anywhere in the entire world comes from the U.S. power sector. Taking action in the U.S. power sector will make a difference on the costly impacts of climate change. I want to talk about 2 reports that I have recently co-authored in which we found, first, that many observers have raised concerns about EPA's proposals and their effects on electric system reliability. Such warnings are entirely normal whenever there is a major change in the electric industry, and these warnings play an important role in focusing the attention of the industry on taking steps to ensure reliable electric service to Americans. Second, natural gas is putting pressure on coal and has already led to retirements of coal unrelated to environmental regulations. Given the significant shifts already underway in the electric system, the industry is already needing to adjust its operational and planning practices to accommodate changes even if EPA had not proposed this regulation. The reliability practices in the industry have been used for decades, and they provide a strong foundation from which any reliability concerns about EPA's regulations will be addressed. Third, the Clean Power Plan provides states with a wide range of compliance options and operational discretion that can prevent reliability issues while also enabling reduction of carbon pollution. Experience has shown that such approaches provide seamless, reliable implementation of emissions reductions targets. By contrast, stakeholders' concerns about the Clean Power Plan presume that there will be inflexible implementation. They are based on worst-case scenarios and assume that policymakers, regulators, and importantly, the market will stand by on the side until it's too late. And there is no historical basis for this. The lights have not gone out when we have had industry changes. Fourth, the industry, its regulators, and the states are responsible for ensuring electric system reliability while reducing carbon pollution from power plants as required by law. These responsibilities need not be in tension, as long as all parties act in a timely way and use the many reliability tools at their disposal. These issues will be solved by the dynamic interplay of actions by regulators, entities responsible for reliability, market participants, as they always are, with many solutions proceeding in parallel. This is one reason why a recent survey of 400 utility executives found that more than 60% felt optimistic about the Clean Power Plan and either supported the emissions reductions target or would make them more stringent. The markets tend to respond to clarity and precision in rules rather than uncertainty of the sort that would be introduced by this bill. Fifth, PJM, the grid operator for the nation's largest competitive wholesale market and serving customers in 13 states and the District of Columbia, is already adapting to changes underway in the electric industry. PJM's own analyses demonstrate that regional, market-based approaches can meet clean power goals that at lower cost with retirements spread out over a period of time. These results indicate that energy efficiency and renewable energy will in fact lower the cost of compliance and lower the exposure to coal plants associated with retirements. Based on our analyses and experience, we conclude that the impacts on electricity rates from well-designed pollution control programs will be modest in the near term and can be accommodated by long-term benefits, in other words, lower electricity bills and positive economic value to states' economies. States have a long track record of using various regulatory tools to encourage programs and investments that minimize the cost of electricity service, consistent with all sorts of public policies ranging from taxes, zoning issues, environmental programs, reliability issues, labor requirements, and states figure out how to do that in a least cost way. Although states differ in many ways, every single state has programs, policies, and practices that will enable them to sit in the driver's seat to figure out how to best accommodate changes being introduced by this important carbon control requirement. Market-based mechanisms in particular offer unique opportunities to minimize cost while reducing carbon pollution. And finally, states have a very long track record of taking steps necessary to protect low-income customers from the hardship associated with electricity rates. Thank you very much.
Thank you. Our next witness is Melissa Hoffer, who is the Chief Energy and Environment Bureau, Office of the Attorney General of the Commonwealth of Massachusetts. So you're recognized for 5 minutes, Ms. Hoffer.
Thank you, Chairman Whitfield.
And is the microphone on, and move it close?
Is that better? There we go. Thank you, Chairman Whitfield, Ranking Member Rush, and members of the committee. Our office really appreciates the opportunity to be here today to provide testimony on EPA's Clean Power Plan and the proposed Ratepayer Protection Act. Section 111D authorizes EPA to establish standards for any emissions from existing sources that endanger public health or welfare but are not regulated under the National Ambient Air Quality Standards Program, or the NAAQS program, or the Hazardous Air Pollutant Program, the HAP program. The 1970 Clean Air Act legislative history confirms that Congress intended that these three programs together would ensure no gaps in regulation of stationary source emissions that pose danger to public health or welfare. Courts have therefore held that these provisions collectively establish a comprehensive program for controlling and improving the nation's air quality. Let's be clear. Those who challenge EPA's authority are taking the position that simply because EPA is, on the one hand, regulating emissions of hazardous pollutants from power plants, it may not also regulate emissions of carbon dioxide, which is a different type of pollutant not regulated under the Hazardous Air Pollutant Program. The Clean Power Plan imposes no double regulation of the same pollutant. Rather, it proposes to do exactly what Congress intended, use Section 111D to regulate a pollutant that is not regulated under either the NAAQS or the HAP programs. It makes no sense that EPA's opponents would exclude the largest sources of carbon dioxide, which are power plants, from regulation under Section 111D simply because they also happen to be huge sources of different toxic air pollutants. That interpretation is not supported by the text of the statute or the legislative history of the 1990 amendments. The more reasonable interpretation is that Congress intended for EPA to do both. There is no evidence that Congress intended with the 1990 amendments to make a sweeping, substantive change to Section 111D. In fact, to the contrary, Congress specifically provided that EPA's regulation of emissions under Section 112 must not diminish Section 111D requirements. Accordingly, EPA has long regulated source categories under both 111D and Section 112, and I've provided some examples in the materials attached to my testimony. In the 4 presidential administrations since the 1990 amendments, EPA has consistently interpreted Section 111D to require regulation of any air pollutant not regulated under the NAAQS program on the one hand or the HAP program on the other. Opponents' interpretation would effectively gut Section 111D, undermining its function as recognized by the Supreme Court of the United States in AEP versus Connecticut, which is to provide a means, and this is a direct quote from the decision, to seek limits on emissions of carbon dioxide from domestic power plants.
They ignore the Senate amendment and the fact that the House amendment itself is subject to multiple readings. Consistent with the D.C. Circuit's rulings, EPA has correctly attempted to harmonize the House and Senate amendments to the extent they appear inconsistent. The discussion draft's compliance extension provisions are not necessary. The D.C. Circuit may stay any EPA final rule if it finds the party seeking a stay has demonstrated that it's likely to prevail on the merits. Without the relief, it would be irreparably harmed. The issuance of the stay would not substantially harm other parties interested in the proceedings, or, on balance, the stay would favor the public interest. The discussion draft would jettison this careful balancing, which has been a part of judicial tests for over 50 years, in favor of what is effectively an automatic stay rule that would halt Clean Power Plan implementation for years during the pendency of any litigation without regard to the merits of the claims, the impacts to other interested parties, or the consequences for the public interest. It would also create an unprecedented escape hatch for states wholly to opt out of urgently needed carbon dioxide pollution control requirements solely on the basis of unverified claims regarding cost or purported reliability concerns. With the passage of the 1970 Clean Air Act, Congress established national air pollution control requirements, and it employed a cooperative federalism model to implement those requirements. The discussion draft's opt-out provision would break the promise, backed by the federal government, of the Clean Air Act that states and EPA will work together to protect public health. The Clean Power Plan's flexible approach leverages states' innovation and expertise to achieve cost-effective reductions of dangerous global warming pollution. For example, Massachusetts is part of the Multi-State Regional Greenhouse Gas Initiative, or RGGI, which instituted a mandatory power sector cap-and-trade program since 2009. When RGGI went into effect, the RGGI states have reduced regional power sector carbon dioxide emissions 40% below 2005 levels by encouraging shifts to less carbon-intensive fossil fuel generation, increasing reliance on renewables, and reducing energy demand through efficiency. Regionally, in the first 3 years of the RGGI program, RGGI added $1.6 billion to the regional economy and created thousands of new jobs in the process. As a result of RGGI, electricity consumers, including households and businesses, enjoy a gain of over $1 billion as their overall electricity bills drop over time. The Clean Power Plan would Massachusetts to rely on what we know works, including RGGI, to achieve the required carbon dioxide reductions. And that is good for our economy, due in large part to our innovative energy and environmental policy. Clean energy is now a multi-billion-dollar sector in Massachusetts, supporting double-digit job growth.
Ms. Hoffer, I'll let you go over 1 minute and 20 seconds. At this time, I'd like to recognize the gentleman, Mr. Sunday, who is the Manager of Government Affairs, Pennsylvania Chamber of Business and Industry, for 5 minutes.
Thank you. Chairman Whitfield, Ranking Member Rush, members of this committee, my name is Kevin Sunday, Manager of Government Affairs for the Pennsylvania Chamber of Business and Industry. It is an honor to appear before you today to express our concerns regarding EPA's Clean Power Plan proposal and also to support Representative Whitfield's ratepayer protection legislation. As background, the Pennsylvania Chamber of Business and Industry is the largest broad-based business advocacy association in Pennsylvania, and our members are of all sizes and industrial sectors. All our members need energy to survive and compete, and so do Pennsylvania's citizens. Our unemployment rate in Pennsylvania is below the national average, and we have made substantial and documented reductions in air pollution over the past decade. We are the second leading state in total electricity, natural gas, and nuclear power generation, and we are fifth in coal production. Our manufacturing sector is the 8th largest in the nation, employing almost 600,000 people. To cite but one example about how our manufacturers need power, one of our member companies involved in processing natural gas worked with the local utility to install a dedicated local substation to give them the voltage they need to operate. Their facility, I would add, requires hundreds of local workers, many of them union tradesmen. Further, that same utility is investing in tens of millions of dollars in infrastructure in the Marcellus shale play, also using union labor, to deliver the power that other drillers and manufacturers will need. But unfortunately, EPA's proposal threatens Pennsylvania's biggest competitive advantage, which is low energy prices. The significant costs of this rule, by EPA's own estimation, will result in relatively small reductions in global emissions of less than 0.5%, likely soon to be eclipsed by development abroad. We have a number of questions about EPA's Clean Power Plan, which I've included in greater length in my written testimony, but generally here are the three key ones. Are building blocks 1 and 2 truly realistic in a restructured generation market like Pennsylvania's? Why is 71% of Pennsylvania's goal based on an expectation that we mandate incredibly high amounts of renewable generation and energy efficiency requirements? And why is Pennsylvania being punished for being an early adopter of renewable generation and energy efficiency? In the Clean Power Plan, Pennsylvania's renewable goal is the second highest in the nation, an almost 800% increase over current levels, and we're expected to deploy it at a faster rate than any other state. Senator Bob Casey Jr. made a great point in his comment letter to EPA that Pennsylvania is, quote, second to last in terms of technical potential for meeting the overall needs of its own energy sector through renewable generation. To get to EPA's goal of 30,000 more gigawatt hours, ratepayers are going to have to fund extremely expensive solar, geothermal, or other renewable projects, something they unfortunately know all too much about. In 2004, almost a decade before EPA's 2012 baseline year, Pennsylvania passed the Alternative Energy Portfolio Standards Act. To highlight one of the problems with this act, between 2008 and 2013, the AEPS mandates doubled from about 5.7% to 10.2% of electricity sales, but the annual cost of compliance increased 54-fold. By the time we get to the peak mandate under existing law of 18% in 2021, the cost of electricity statewide could increase by as much as $3.2 billion. Also ignored in the Clean Power Plan's 2012 baseline is our energy efficiency law, which was passed in 2008 and to date has cost consumers $1.7 billion to reduce their electricity consumption by 4.5%. Utilities and ratepayers are also expected to spend another $735 million over the next 3 years for additional energy efficiency mandates. And all told, Pennsylvania spends the 5th highest amount annually of any state to comply with energy efficiency mandates. I want to now highlight our experience with the Chesapeake Bay TMDL, another multi-billion-dollar federal mandate that we believe is instructive in this conversation. Originally, EPA pledged flexibility, but then the agency settled with environmental groups and gave Pennsylvania regulators just 6 months to develop a federally enforceable compliance plan. Now, reminiscent of a 111D FIP, EPA has said that if the target reductions are not met, EPA will sanction the state and permitted facilities. There also remains the continual threat of citizen suits to ratchet up enforceability and compliance timeframes. And just one final point to crystallize this at a local level. The City of Lancaster spent $150 million in sewage improvements and millions more in green infrastructure as part of their Bay TMDL mandate. EPA hailed them as, quote, leading the way, a national example. Flash forward to this past winter, EPA is pressuring city officials to sign a new consent decree to get additional reductions at an additional cost to taxpayers of as much as $400 million. Again, thank you for your time this morning and afternoon, and I look forward to answering any questions you may have.
Well, thank you, Mr. Sunday. And our last witness is Mr. Paul Ciccio, who is the president of the Industrial Energy Consumers of America, and you're recognized for 5 minutes. And be sure and turn it on.
Thank you, Mr. Chairman, Ranking Member Rush. The Industrial Energy Consumers of America represents energy-intensive, trade-exposed companies. These companies consume 73% of all of the electricity in the manufacturing sector and 75% of the natural gas. As a result, small changes to the price of energy have relatively large impacts to our global competitiveness. As a sector, we use 40 quads of energy, and this has basically not changed in 40 years. In that same time period, the value-added output of the industrial sector has increased 761%, a tremendous success story. The industrial sector is the only sector of the economy whose greenhouse gas emissions are 22% below 1973 levels. These industries are very energy efficient. IECA supports action to reduce greenhouse gas emissions so long as it will not impair our competitiveness. We must have a level playing field with global competitors. Several countries that we compete with control electric and natural gas prices to their industrials and provide subsidies and/or practices to give them a competitive advantage. If we were the military, one would say that we are engaged in hand-to-hand combat. As proposed, the Clean Power Plan would impose significant electricity and natural gas costs and accomplish too little to reduce the threat of climate change. All costs of this unilateral action will be passed on to us, the consumer, and will directly impact competitiveness and jobs. The EPA cannot look at the Clean Power Plan in isolation from the significant cumulative costs that it will impose on the industrial sector, either directly or indirectly through a number of recent rulemakings. Since 2000, the manufacturing sector is down 4.9 million jobs. Since 2010, manufacturing employment has increased 525,000. We are in the early stages of recovery and fear that the Clean Power Plan could threaten this recovery. In contrast, for example, China, a primary competitor, has increased industrial employment by 31% since 2000, and the U.S. manufacturing trade deficit since 2002 has grown to $524 billion, of which 70% is with China. China's industrial greenhouse gas emissions have risen over 17% just since 2008. China produces 29% more manufactured goods than we do in the United States, but emits 317% more than the U.S. manufacturing sector. That's over 3 times as much. But despite our low greenhouse gas levels, the EPA will increase our costs and make it easier for China's carbon-intensive product to be imported, which means the Clean Power Plan will be directly responsible for increasing global greenhouse gas emissions. There are consequences to increasing energy costs on the industrial sector, and it's called greenhouse gas leakage. And the EPA so far has failed to address its impact and has thus underestimated the costs. For example, when a state's electricity costs rise due to the Clean Power Plan, these industries with multiple manufacturing locations will shift production and shift their jobs to low-cost electricity states, along with the greenhouse gas emissions, creating state winners and losers. When they do, it will increase the price of electricity to the remaining ratepayers in that state. If these industries still cannot be competitive, they move offshore, moving jobs and greenhouse gas emissions, accomplishing nothing environmentally. One needs to only look towards California that has high electricity costs. Since AB 32, to our knowledge, there is not a single energy-intensive, trade-exposed company that has built a new facility there. Instead, California is importing manufacturing product, they're forfeiting jobs, increasing global greenhouse gas emissions. And the same is true for the EU ETS. It is for this reason that we urge policymakers to hold offshore manufacturing competitors to the same carbon standard as domestic manufacturers. Thank you.
Thank you, Mr. Ciccio, and thank all of you again for your comments. And I'd like to recognize myself for 5 minutes of questions. These hearings are always so interesting because when you listen to the testimony, it raises so many questions in your mind, and sometimes you even question your sanity in some ways. But I was listening to Ms. Hoffer, and she was so emphatic in her legal defense of the 111D regulation, for example. And I know, Mr. Triscoe, that you are an accomplished Clean Air Act lawyer as well. And in my opening comments, I talked a little bit about, I'm not an expert in the Clean Air Act, but as far as I know, in this proposed rule, they basically view a state as a source because there's a cap for that source. And so to comply with the regulation, as they say, they give states the flexibility to go outside the fence to address it. Would you find would you agree with me that this is an unusual interpretation and legal analysis by EPA to decide that it gives them the authority to do this regulation?
Absolutely, Mr. Chairman. Now, Professor Tribe has discussed these issues at some length, both in his testimony and in his written commentary on the rule. There is another aspect of 111D relating to the term standard of performance that I believe is extremely problematic for EPA's attempt to bring in energy efficiency, outside the fence measures, and renewable energy requirements, also outside the fence, that call into question the basic legal soundness of EPA's approach. When you look at the fundamental architecture of the Clean Air Act, with its scheme of regulation for criteria pollutants on the one hand, regulated largely under Titles 1, 2, and 4, and hazardous air pollutants such as mercury on the other hand, I think it makes perfect sense that in this instance, sources that already are subject to a MACT requirement under Section 112 be exempt from Section 111D requirements, because exposing them to 111D would in effect create a form of double regulation. Moreover, had Congress intended, the last time it visited the Clean Air Act in 1990, to include CO2 regulation as a possibility under Section 111D, I would note that CO2 was addressed explicitly in the context of regulation of automotive tailpipe emissions in an amendment proposed in the Senate by Senators Worth and Hines. The Senate rejected that amendment, indicating that CO2 emissions should not be regulated.
You're exactly right, and I appreciate your making that comment. I might say also, Ms. Hoffer was talking about the great progress that's being made in Massachusetts, and I understand how, and by the way, it exemplifies why some states get so upset about what is going on here. In your view, Massachusetts has been progressive and have really tried to address the issue. And one of the consequences of that is that Massachusetts has the third highest electricity rates in the country per kilowatt hour. And between 2014 2015 went up about $3 per kilowatt hour. And that's a decision that they have made. But other states have decided that they don't want to pursue that right now. And the impact of this is on those people. You talked about this, Mr. Triscoe, that 1/2 the households in the 31 states that you all looked at, 38 million households, their median income is $23,000. And so when you talk about upping electricity rates on these people who have no other choice, it's a dramatic impact on them. And I didn't have an opportunity to get into it, Ms. Johnson, but I read your article. Here you've got one of the cleanest coal plants in America operating. You spent $500 million on it. It has a useful life up through 2045, and you're probably going to be forced to close it down. Is that correct?
That is correct, Mr. Chairman.
I mean, it's unbelievable. My time's expired. Mr. Rush, you're recognized for 5 minutes of questions.
Yeah, Ms. Hoffer, you have been the target of some pretty stringent remarks by the chairman, and I just want to give you an opportunity to respond. So what's your reaction to some of the remarks concerning your fine state and the work that you are doing in Massachusetts, and the rate, the cost of energy or electricity in your state? Would you want to respond?
I'd also briefly respond to Mr. Triscoe's point. Since 1977, in fact, EPA has regulated the same sources under both 111D and 112. And just quickly give you the examples of those. So there is the regulation of landfills under Section 111D for methane and non-methane organic compounds, and under Section 12 for vinyl chloride, ethyl benzene, toluene, and benzene. Then there is also regulating fluorides from phosphate fertilizer plants under Section 111D, and regulating hydrogen fluoride and other pollutants under Section 112. So this is a long-standing practice of EPA. And on the cost point, there's a couple things I'd like to add. So with the Regional Greenhouse Gas Initiative, or RGGI, the states, most of the states had to pass implementing legislation to put the RGGI program into work. And many of the participating states decided to take the allowance auction proceeds, so the amount of money that's paid for an allowance to emit 1 ton of carbon dioxide, and use that to promote energy efficiency. So Massachusetts has been ranked in, first or among the first states for energy efficiency in the country for the past couple of years, because we've been able effectively to take that money and invest it back into energy efficiency in our state, which over time has had the effect of lowering electric bills. And we had this exchange earlier today about electricity rates versus electricity bills. And for those of you who live in states where the electricity markets have been deregulated, you know when you get your energy bill, there's a couple different charges on it. There's the charge for the electricity itself. There's often a distribution charge, which is for your local wires and the ability of the distribution companies to deliver service to you. And then there's a transmission charge. And what you see over time with efficiency improvements is that the total bill comes down. And that's what you really want to focus on with this. And I think we can hear more from other witnesses on the panel today as well. But huge beneficiaries of the energy efficiency under RGGI have been the industrial ratepayers. And that's been a real plus for Massachusetts.
I want to thank you. Dr. Tierney, according to the National Climate Assessment, if we do not seriously invest in addressing climate change impacts now, we can expect to see more expensive and costly future damages affecting almost every facet of our society, from negative health impacts to stressing our infrastructure and water systems to harming our national security up to and including hurting our overall economic growth. In your professional opinion, do you believe that the proposed CPP is both flexible and provides states with feasible deadlines so as to not drastically impact reliability and or costs for consumers? And also, why is it so vital that we act now rather than kicking the can down the road?
Thank you very much for that question. As a co-lead author of the Energy Production and Use chapter of the National Climate Assessment, we took a survey of the literature on the costly impacts already being faced by Americans associated with the effects of climate change. Florida, for example, faces tremendous costs of a variety of sorts, as do California. I think of California, and the well-known costly drought conditions are extraordinarily in terms of their cost on consumers. One of the things that's valuable to think about as we think about this Clean Power Plan, right now we have the ability for people who are using fossil fuels to emit, to produce electricity, are polluting for free with regard to carbon. No wonder it's cheap to do that, because you're really dumping some kind of cost on somebody else. And as a result of that, the Clean Power Plan provides a lot of flexibility for states to figure out how to address that problem quite creatively. I think of a state like Florida, which indeed hangs as a separate part of the electric system. Florida has the ability to establish some kind of mutual assistance program with other states, enabling the two states to have more affordable compliance programs for both of them.
Gentleman's time has expired. This time, recognize the gentleman from Texas, Mr. Olson, for 5 minutes.
I thank the chair and welcome Mr. Triscoe, Ms. Johnson, Ms. Tierney, Ms. Hoffer, Mr. Sunday, and Mr. Sissio. Long day, I know that, but thank you for coming this afternoon. My first question will be for Mr. Triscoe and Ms. Johnson. And in your testimony, sir, you talked about how our seniors may be hit the hardest by increases in electricity prices. And you also say they may have the lowest ability to absorb these costs with their energy demands. And my mother-in-law, my kids call her Mamie, is case in point. She moved from cool, dry Southern California to hot, humid Southeast Texas 3 years ago. She's on a fixed income. Energy is one of her biggest expenses, air conditioning. If she has some increase in prices because of this rule, she might not have the quality of life she has currently because her prices will go up. She might not be able to keep that air conditioner where she wants it. And I don't want that to happen to her. So could you elaborate on the issues seniors face across America, sir?
Happy to, Congressman. I think it's important to bear in mind when looking at the electricity price increases that I cite in my testimony, to bear in mind that the NERA analysis, and I've used the most conservative NERA numbers in this report, including all 4 EPA building blocks. But the NERA analysis included in its baseline the rate increases associated with the EPA mercury rule, the MATS rule. And that compliance is beginning now and will continue over the next several years. There will be significant increases in electricity prices as a consequence of the compliance with the MATS rule. So these numbers are additive on top of an increasing trend. The impact on fixed income seniors is fairly obvious because most of the fixed income seniors fall into the lower income categories, either below $50,000 or in many cases below $30,000 a year. You're basically looking at Social Security recipients receiving at best COLA increases, which barely keep pace with the rate of inflation. So if your electric bill goes up by, let's say, 15 to 20% in real terms compared to what it is today, as a consequence of...
Like my Mamie, that's my mother-in-law, yes, sir.
Well, as a consequence of these regulations, you are for those individuals really creating a question of heating versus eating. And there's survey evidence that bears that out.
Ms. Johnson in Florida, large senior population, how would that impact your seniors back home in Florida?
Very similar situation, Congressman. Thank you for the question. As I mentioned, a third of our population that we serve have incomes below the poverty level, and over 75% of them have incomes below $75,000. Although that's not poverty level income, that is in the lower to mid bracket of incomes. And as Mr. Trisco mentioned, and I agree, those lower income households spend more money on their electricity service per month. If you increase their bills, if you increase the rate that they pay, even if you're trying to work with them to decrease the amount of electricity that they use, they will disproportionately be impacted negatively by an increase.
And there's a limit too, because seniors feel heat more than normal people. I mean, they want the air colder. My mother-in-law keeps it really cold because that's what she's used to. And her body gets older, she can't take that extreme heat. So thank you for your perspectives. My final question is for you, Mr. Sunday. You mentioned your testimony that Pennsylvania has a competitive advantage because of low energy prices. I mean, it sounds like jobs are coming to Pennsylvania now, flocking there. And as you know, the steel industry went away to Asia about a decade ago. So how these increase in prices from this rule impact your ability to recover and thrive in Pennsylvania?
We're on the verge of a manufacturing renaissance, and frankly, we cannot afford higher energy prices. I mentioned the energy efficiency laws to the point of steel. The Industrial Energy Consumers of Pennsylvania gave us some data that the state's standing energy efficiency laws in some utility jurisdictions adds $40,000 a month in their bills. That's quite a few employees that they can hire a year. We stand on the precipice of turning things around in Pennsylvania, but we don't want to turn back now.
Mr. Sisio, you mentioned jobs coming back to America. How about jobs leaving if this rule goes into effect? How many jobs will fly overseas again?
Well, we don't know exactly how many jobs because we won't know that until we find out what the final rule is. But let's talk in practical terms here. Let's just look at two industries that use a lot of electricity, steel and aluminum. The operating costs, the percent of electricity of operating costs of aluminum is about 30% of the cost. Relatively small changes has a huge impact on whether they produce here or produce somewhere in the world. Steel is about 20 to 25%. So you can see that high operating cost has a huge sensitivity to price change.
Thank you back.
Thank you. At this time, I recognize the gentleman from New Jersey, Mr. Plone, for 5 minutes.
Thank you, Mr. Chairman. I know everyone's concerned about rates and reliability, so, Ms. Tierney, I wanted to ask you a little bit about rates. It appears to me that the EPA analysis shows some increases in electricity rates, but it also shows that by the end of the compliance period, electricity bills are expected to be lower. So first, why bills would be lower at the end of the program, and second, for the projected rate increases, how do they compare to rate increases that we've already seen over time?
Thank you, Congressman Pallone. One of the reasons why EPA projects that there will be lower electricity bills is the point that's been described previously. If you are using less electricity because of energy efficiency, you're buying fewer units of electricity. Even though the unit price of electricity might rise in a small percentage, your total bill in terms of the quantity you use and the price, that's going to lead to a lower cost impact. My colleague here from Massachusetts has just reported that one of the things we've observed in the Northeast and Mid-Atlantic states is those strong investments in energy efficiency get you 2 bangs for bucks. It means that there are a lot of jobs locally in the local economy to put on insulation and a variety of things. The consumer ends up using electricity, and then over time, you don't have to run the most expensive power plants on the system to produce electricity, and it's a virtuous cycle in that regard. So that's the reason why the EPA's logic there is that there will be lower bills over time.
Can I ask you, are there larger forces than the Clean Power Plan at work with regard to increased rates? Is the power system already undergoing change for reasons unrelated to the Clean Power Plan?
Absolutely. Over the last, since the shale gas revolution began to lower the price of a domestic fossil fuel, that has put pressure on existing aged, inefficient coal-fired power plants. We've seen reductions in those coal-fired power plants in terms of their operations. We have seen no reliability problems associated with that. And in fact, we see today the announced retirements of coal plants around the country are being flanked on the other side with an equal amount of proposals for new gas-fired power plants, new renewable infrastructure, new transmission, new gas pipeline infrastructure. As a result of that, we are seeing the market respond very favorably to the signals about lowering supply.
Well, in the same vein, you recently took a look at the impact of the Clean Power Plan on electric systems reliability. Do these doomsday claims have any merit?
They don't, in my opinion. The doomsday scenario is helpful to all of us because here we are talking about it. It does not suggest that everybody will stand by. I have never seen the mission-oriented electric industry stand by when that has to face a reliability issue. They will do that now. States are very responsible for this, so I think that the worst-case scenario, gloomy outlook, is one that we won't see happen.
Thank you. Ms. Hoffer, Massachusetts has come out in support of the EPA's proposed Clean Power Plan. It's clear from your testimony that EPA has the legal authority for the plan. Could you briefly comment on the logic of legal challenges to a proposed rule? How about legislation that seeks to halt, alter, or undermine a proposed rule? I would say that challenging a proposed rule either in the courts or with legislation is a bit premature, but what do you think?
It's absolutely premature, and there's no need for it. And in fact, as Administrator McCabe said earlier, it would be extremely disruptive. Climate change is an existential threat to humanity, and there is a significant cost associated to that, which affects all sectors of the economy. So one way to think about it isn't the status quo compared to doing the Clean Power Plan, but increasingly expensive climate response costs compared to doing something now, which is already a bit late to reduce and abate the threat. EPA has estimated that climate and weather disasters have affected the American economy to the tune of over $100 billion since 2012 alone. So we need to be doing things as quickly as possible, and there's already a rational legal limitation. If, for example, as I explained earlier, a moving party came into the court and wanted to challenge the final rule and was able to make out a case that the rule should be stayed during the pendency of that challenge based on the traditional standards that courts typically apply for a stay would be granted. So we already have a way and a legal mechanism that's well recognized that could be applied in this instance, so it's not necessary.
Thank you, Mr. Chairman.
Gentleman's time's expired. We have 2 votes on the House floor. I believe we're going to be able to finish our questions before we go. So at this time, I'd recognize the gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you. I'll try to be brief here quickly on this. The statements earlier today by Ms. McCabe that the increased cost of about $8.5 billion is going to lead to lower utility bills, I found fairly incredible. And it's just further manifestation, I think, of this disturbing trend coming from the administration over the years and calls into question, I think, their credibility. Look back on some of the statements that we've dealt with. Al-Qaeda's on the run in 2012. 2014, we heard Yemen is a counterterrorism success story, and we found that to be false as well. We heard over the years that the EPA, the more EPA regulations create jobs. For every $1 million in regulations, it creates 1.5 jobs. We're hearing about this proposed Iranian deal is good for Israel, but the Prime Minister says absolutely that's false. Now I'm hearing this is going to save money for the consumer. So, Mr. Triscoe, can you respond to that? I just thought that was an outrageous statement and really called into question a lot of their credibility.
Congressman, yes, thank you. The reason that EPA has presented such a low estimate of the annual compliance costs of the Clean Power Plan is that it is netted out from those costs the assumed savings from energy efficiency initiatives. Now, NERA's analysis using the 4 building blocks of the EPA rule, and this is the cost to consumers of investments in energy efficiency to meet the EPA targets, indicates a cost to consumers, and this is in net present value terms, of $560 billion. That means Americans will be asked by this rule, American consumers will be asked to spend $560 billion in investments in energy efficiency. Congressman, I believe that estimate of that extent of energy efficiency investment is simply fatuous. As of just a few years ago, the most recent data, and these don't change very quickly, the average American house is owned for a period of 7 to 8 years. You cannot recover a major investment such as in replacing sliding glass doors or an HVAC, a heat pump system. You cannot recover those costs in the space of 7 to 8 years. You can do relatively simple things like attic insulation and weather stripping and that sort of thing, but those don't get you close to the targets that EPA is advocating for states in this rule. So if you're going to have energy efficiency, to the extent that EPA is advocating it, consumers ought to be able to shell out on the order of $500 billion to pay for it.
In deference to time, I yield back the balance to help out.
The gentleman yields back. This time recognize the gentleman from Virginia, Mr. Griffin, for 5 minutes. Thank you.
Thank you very much. Ms. Hoffer, we're just going to disagree on the law. Mr. Triscoe, you and I are going to agree on the law as to whether or not the EPA has authority under 111D. But I would submit to both of you that in this case, on Thursday of this week, the EPA is going to argue in front of the U.S. Court of Appeals for the D.C. Circuit that it is premature to take the question up as to whether or not they have authority under 111D. Now, there's some other arguments as well, but at the very least, it would seem to me, in the matter of efficiency, settling this issue more quickly as to whether or not there's even authority to go forward with the regulations would be in the interest of the American public. Mr. Triscoe, would you not agree with that the EPA ought to say, okay, at least as to whether or not we have authority, since we already regulate under 112, can the court rule on that so we can move forward to the Supreme Court? Because we all know that issue is going to end up in the Supreme Court. Wouldn't you agree?
Congressman, I would agree, and let me cite another precedent that is occurring in the here and now. The Supreme Court will hear arguments and render a decision in the challenge to EPA's mercury rule. There are power plants that are being retired, basically being put into stranded asset category today. this month, this year, tens of thousands of megawatts of capacity. The Supreme Court could vacate the EPA Mercury rule. In that event, wouldn't it have made sense before those plants were retired and rendered stranded
And those
assets
jobs lost?
to have the answer?
Yes, sir, it would.
To have the answer.
And that screams out for this proposed draft to be passed. Wouldn't you agree?
Yes, sir.
All right. And Ms. Johnson, likewise, you would feel that you're about to have some stranded costs. Wouldn't you like to know in advance that the EPA at least has the authority to promulgate these regulations? You might still be opposed to them, but wouldn't you like to know whether they have the authority before you're forced to shut down that facility?
I certainly would, Congressman.
And that screams for this piece of legislation, this draft legislation to be passed. Wouldn't you agree?
Yes, I agree.
And you would agree then with the State Corporation Commission of Virginia when they said that because of stranded costs in part, but contrary to the claim that rates will go up but bills will go down, experience and costs in Virginia make it extremely unlikely that either electric rates or bills in Virginia will go down as a result of the proposed regulation. You certainly have no reason to disagree in Virginia, and for the people that you serve in your area, would that also be true?
I believe that's true. I don't know how you could retire a plant prematurely when there is valuable life left in it and have to replace new generation to take that up and pay for it twice and not have the cost go up.
Yes, ma'am. And Mr. Ciccio, one of the things I wanted to ask you about, if I heard your testimony correctly, the Chinese produce how much more product today than we do, percentage-wise?
I believe it's 23%.
About 20-some%.
Yep.
And yet their carbon footprint is how much more for that production?
300% more.
So when we make it difficult for businesses like Mr. Sunday's businesses to do business in Virginia,
Right.
those business or Virginia, United States, Pennsylvania, from Mr. Sunday's case, we send some of those jobs, not all of them, but some of them will go to places like China or India. Isn't that correct?
Well, that's correct. Turn it around. Look at it this way. If you create jobs in the United States and you don't import from China, you're reducing global emissions.
So this may actually have a contrary effect on the environment, where everybody's claiming that this will help the environment by pushing jobs to places like China, Vietnam, India, wherever. We could be making the environment worse. And I note that India has said they're not planning on cutting back on carbon. They're going to use more carbon. They're going to use more coal because it's affordable to produce the energy, to produce jobs, and they want to catch up with the U.S. and China. Isn't that correct?
That's correct. And even Japan just last week announced that they will build 40 coal-fired power plants. So it's not just developing countries.
And the Germans as well are building some more coal plants.
correct.
And, of course, one of the things that people often forget, because they'll say that we're the, I think somebody earlier tonight, they said we're, second only to China in carbon footprint. We are the world's third largest or most populous country. We are the world's largest economy, and we're currently producing the second most products. So that accounts for some of this, and we have benefited the rest of the world with our innovations. We can benefit them now with our innovations without the force of government regulation. Particularly this particular regulation we're discussing today, the Clean Power Plan, by moving forward to make us better and more efficient in the factories, as opposed to debilitating folks like in my district who don't have the money to spend on these increased electricity. Thank you so much. I yield back.
Thank you. Mr. Rush.
Mr. Chairman, I ask unanimous consent to enter a number of letters into the record from various organizations, public health organizations, environmental public interest, and environmental justice organizations, and consumer groups. So I ask unanimous consent that these letters be entered into the record.
Without objection, and then I would like to submit for the record by unanimous consent the comments that were submitted to EPA regarding its proposed 111D rule by the National Black Chamber of Commerce, the United States Hispanic Chamber of Commerce, and National Association of Realtors. We would also like to submit a statement in support of the Ratepayer Protection Act by the National Association of Home Builders. So that concludes our hearing. You all were very patient. Thank you very much for taking time to focus on this important issue. We look forward to working with all of you as we move forward. We'll keep the record open for 10 days, and that will conclude today's hearing. Thank you very much.
Thank you.